Can you hear me?
Yes. I'm going live here, so let me just. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2023-2780 DP, Taylor Coyer versus Jalen Naylor. Today is Monday, July 1st, 2024 at 10 a.m.
Court will note the appearance of Ms. Paisno on behalf of the plaintiff, Mr. Scott on behalf of the defendant. This matter is before the court on the plaintiff's motion for child support. I have read all the pleadings in this matter. It does appear based upon that the court is going to have an evidentiary hearing to decide the ultimate issue, as there are a number of issues the court has to decide in this matter. Is there anything else you have to add, Ms. Paisno?
No, Your Honor, I do believe that the court will need an evidence. Would ask if this court could start some temporary support. My client has gone without support on this minor child in September.
Okay, Mr. Scott, your thoughts?
Yes, thank you, Your Honor. I have reached out to Ms. Paisino. We have been working well together in my judgment, and I did suggest that a sum of $2,000 per month be granted presently, pending your review and or the friend of the court's review, because as the court may be aware, if Mr. Naylor had paid anything, it could have been determined involuntary payment. And so I'm happy to enter an order at this time at $2,000 per month if it's within the court's discretion to do that at this time, adjusted either upward or downward, depending on how you decide or how the friend of the court might rule.
Okay. Well, the court does note, at least Mr. Scott in his answer says at one point the parties had agreed to the $2,000 per month. I don't know if that's the case, and I don't know if the proofs will establish that, but at this point the court will order the sum of $2,000 per month commencing on today's date, July 1 each month thereafter, subject to obviously modification as we proceed, and the court will schedule an evidentiary hearing to determine all the issues that we have to arrive at the correct support amount. Anything else, Ms. Paisno?
Nothing further, Your Honor.
Mr. Scott?
I have nothing further, Your Honor.
Ms. Paisno, if you would submit that order under 7 day, we will conclude, and then we'll be in touch with you. Is there anything else you need to do, Ms. Paisno and Mr. Scott, before we have an evidentiary hearing? Because I want to make sure if there's any discovery or anything you're doing that we don't schedule it before that.
We may need to have a brief deposition, Your Honor, just on some of the issues, but it would be not a great deal of time is necessary, probably 30 to 45 days at the most.
Okay. Ms. Paisno?
Attorney Scott and I have been working well together, transferring information as needed. So it's be appropriate.
Okay. What we'll do is we'll probably set it sometime later August. If that works into everybody's schedules, and we'll be in touch with you to see what works with your schedules and your clients as well. And then we will have a hearing. I don't think the hearing would take more than a couple hours, so we'll schedule it at that point.
Just a point of clarification. My client is in Minnesota. Is it okay with the court to do that via Zoom?
Yes.
Thank you.
Okay, thank you. You're free to go. Have a good day.
All right,
Thank you,
thank you,
sir.
Your Honor.
Thanks, Jayla.
Thank you.
See you, bud.
Please unmute. Please unmute. Good morning.
Good morning.
Caitlin Carr.
Yes,
Okay, and what case are you appearing for this morning?
I'm here on behalf of the Polaris versus Evolution
Okay, and you are here representing
on behalf of plaintiff.
Benjamin.
Yeah, Ben Sobchak is also going to be appearing.
All right, I'll place you in the waiting room.
Thank you.
Thank you. Please unmute. Okay. All right. Huntsman, you are here on Hercules, Bradbury.
Before.
Calling case 2024-549 CB Hercules Material Holdings versus Schaefer Ready Mix Incorporated et al. Today is Monday, July 1st, 2024 at 10:06 a.m.
Court would note the appearance of Mr. Bradbury on behalf of the plaintiff, Ms. Hansma on behalf of a defendant, and Mr. Fafarik on behalf of a defendant as well. This matter is before the court on the defendant's motion to compel. We had been in court just last week and addressing various issues in this particular case. Defendant, you can proceed. I've read all of the pleadings, so you don't need to reiterate that. If you just want to respond to, again, the plaintiff's answer, and then we can proceed.
Certainly, I appreciate that, Your Honor, and I trust that you did have a chance to look at all of that. I think it's important in context to understand that my client, Schaefer Ready Mix, is in this case as a defendant because the plaintiff has asserted two tort actions against my client, interference with contract and interference with business expectancy. And so, as you might imagine, defending those claims requires that we understand what specific acts they believe that Schaefer engaged in that would give rise to liability. And so when we prepared these discovery requests, the thrust of them is to figure out what specifically is it you're alleging we did here. And what we're seeing is kind of the classic, well, we know you did something wrong, but we won't know what it is until you tell us. And so where I am in discovery
Ms. Hansma,
is,
so your client's not willing to tell them?
well, my client says we didn't do anything wrong, as you might imagine. So that's kind of where it's turned into this chicken or the egg situation, but they're the plaintiff.
Okay.
And so if they're saying that, Schaefer, you have our confidential and non-public information, which is actually a term of art they use in their complaint, and you used it to interfere with our contracts and our customers, I say back, explain to me, I mean, obviously you don't have to put your trade secrets in court filings, but explain the nature of the information you're claiming we have and how we used it, when and with whom. So this is your complaint, your allegation, and then I get back an objection saying none of that is relevant. And so, and that's the nature of the responses I got to each of my requests. A lot of times it's, well, discovery is not over yet. And as you might recall, Your Honor, discovery was over before you extended it this past week. And so here we are at the end of discovery, and I'm asking, tell us specifically what actions Schaefer took. By way of example, they'll say in their complaint that you went out and you solicited Walbridge, by way of example, this contractor for work. And so I ask in discovery, when and to whom? What conversations are you referring to where you're saying this improper solicitation occurred? And I get nothing. And so if the answer really is, and I'm sure this does happen all the time before your court, if the answer is we think something bad happened, but we won't know until we're done with discovery, that's why the request to admit are included. Because I think the answer right now is we don't have evidence, we think we're going to find it. But if that's the answer, then what I want is I want it under oath that this, to this date, this is every example we know of that would constitute facts giving rise to our cause of action. If they find more in discovery, which they won't, they can supplement. And then when that discovery period is over, we'll be ready for a motion.
Okay, thank you. Mr. Fafarik, what's your position?
I concur with everything that was just said.
Okay, thank you. Mr. Bradbury, anything else?
Yeah, just briefly, Your Honor, because I won't reiterate the things that we wrote in response to the motion. But I think the context of the case, and especially the context of, at least my understanding of the parties trying to resolve the case while discovery was ongoing, is important. So my understanding, again, was that the parties conducted some written discovery in advance of mediation, I assume, on both sides in order to gather some facts and some information which would inform their positions leading into mediation. Mediation, of course, hasn't resulted in a settlement of the case. And so then it was, you know, from plaintiff's perspective, all right, well, investigation phase 2 now, I guess, is underway because we were not able to resolve the case after that round of initial discovery. And that's where we are, Your Honor. So again, the context of the situation, I don't think, is one in which we were truly at the end of discovery. We were nearing the end of the initial discovery cutoff that the court set, but I don't think there was much question, at least in the plaintiff's mind, that what was intended on both sides all along was to extend discovery beyond mediation if necessary, and with the court's permission, in order to conduct more substantive discovery, written discovery, and depositions.
Okay,
Judge,
well, go ahead.
That simply is not accurate. There was never any such understanding or agreement. We had a court order that set forth the parameters of this case and discovery. And as I mentioned last week, we had served discovery early on, and it took 60 days or better for them to respond to it. It wasn't because we were trying to just limit certain things and obtain limited amount of information prior to conducting a mediation. And there was no discussion at the time of mediation of extending discovery any further. We were working under the presumption, the understanding that this case was going to trial here shortly. So there wasn't any deliberate effort to limit our efforts of trying to understand what was being pled in this case whatsoever.
Okay. Well, what the court's going to do, and the court does recall the motion last week where we did extend the discovery. What the court's going to order is that the plaintiff would respond completely to all of the discovery requests in accordance with the Michigan court rules within 14 days of today's date. If they fail to do so, the defendants can proceed with their summary disposition motions that they referenced last week. And then at that time, based upon the summary disposition motions, the court will decide whether the responses and that were sufficient at that time, because on a motion day, I don't have time to go through all of the again, interrogatories, requests for production of documents, or requests for admissions. But we will have to obviously decide that at the time of summary disposition if that's the appropriate action. So, Ms. Hansman, you can prepare an order and submit under 7-day notice.
I will do that. Thank you, Your Honor.
Okay, thank you.
Have a great day.
Thank you.
Good morning, Your Honor.
Good morning.
Good morning.
Please unmute.
Good morning, Judge. Sorry, I'm trying to figure out my camera.
Calling case 2024-1304 CB, Flores Fund REIT LLC versus Evolutions Holdings LLC et al. Today is Monday, July 1st, 2024 at 10:15 a.m.
This matter is before the court on the plaintiff's renewed motion for appointment of receiver. I note that plaintiff, you had attached an order in this matter as, I guess, attachment 1 or exhibit 1, and asked to enter that proposed order. However, that order simply states if the defendant fails to make the payment, plaintiff can renew its motion for appointment. So I don't think you want to do that at this point.
Probably not, Your Honor.
Okay.
Probably.
So if the attorneys, as they speak, if they would identify themselves and the parties they're here on, we'll start with the plaintiff and you can proceed.
Thank you, Your Honor. Ben Sobchak on behalf of plaintiff Flores Fund REIT P73567.
Ron Ryan on behalf of Evolutions Holding LLC.
Okay,
If I may, I think there was a substitution of counsel put forth by defendants. So who's
Caitlin.
representing the rest of the defendants today?
yeah, we had a Miss Carr who had appeared. She dropped off. Now she's back apparently. Miss Carr, and
Good morning.
who are you representing?
Good morning, Judge. This is actually Attorney Caitlin Elias on behalf of Flores plaintiff.
And to be clear, I do represent all the defendants here.
Oh, okay.
So, yeah.
Okay.
Just when we get all the attorneys involved, I don't know who they're representing.
Right, right.
Okay. Shall I proceed, Your Honor?
Yes, go ahead.
Okay. While I'm obviously a little partial, I think the proper outcome here is obvious, especially in light of defendant's response filed Friday. In our renewed motion, we provided Your Honor with several bases to enter the order, which you've pointed out needs to be modified because there's some latent language from the first turn, which we can get taken care of. Starting with the first reason, the prior stipulated order. Flores received no dollars, not a single one, in the 30-day time frame that the court allowed. Evolutions has been in default here from about 12 months now. And even though at our status conference it was represented that they were on track to make the payment, not a single dollar was received. What did happen in those 30 days, though, is that the defendants spent a ton of legal fees on activity in this case and caused Flores to do the same. Most of that activity has now been countered or conflicts with some of the representations in the response to this motion. But the point being, I think that resources should have been directed towards following the order, not questionable litigation tactics. Moving on to the contracts, which I know Your Honor was very focused on in the first hearing. So we're going to build that out for you a bit more. The defendants here have consented to the receivership remedy 10 times in 10 different agreements since the beginning of our business relationship, Flores and them, I should say. They've also waived all defenses to that result or remedy 4 times in 2 different contracts, the last of which was specifically signed off upon by Mr. Ronald Ryan, opposing counsel, and his email to that effect is attached as Exhibit 5 to the motion, where he writes, "I have reviewed the Second Amendment and have no proposed changes." That Second Amendment confirmed all the prior promises and remedies and the waivers and releases. Polaris would not have continued to do business with these folks at that time, but for those contractual promises and waivers, which we are currently relying upon. The response doesn't really question any of that. Instead, it just says it thinks, defendants think that receivership's the wrong remedy. Noted, but that's not really the defendant's choice at this point. What is important in the response at page 3, I believe, is that they write, Evolutions would like to repay Polaris. This is critical because remember, I have answers that are spackled with affirmative defenses that these agreements are somehow not enforceable. I have counterclaims arguing that these agreements are not enforceable. And yet here today, Evolutions would really like to repay us. So I think that judicial admission probably takes care of the affirmative defenses and several of the counterclaims, but that's not going to mean that we don't all have to continue to spend money and time to wade through that. Instead, the response essentially asks the court to allow Evolutions to unilaterally reset its own interest rate, stay all the claims in this case indefinitely while it decides how it wants to work out the quiet title action, and then allow them yet another 6 months to refi. I would draw the court's attention on page 9 of the brief to the Maple Creek Gardens case, Eastern District of Michigan, 2010, where the court said the contractual receivership right is sufficient and there is, quote, little hardship in enforcing the terms of the party's bargain. To be clear, the party's bargain did not contemplate that the loan's repayment or maturity was contingent on Evolution's ability to refi. I personally would not take a loan with a balloon payment if I only thought that I would be able to repay it by refining with some other third party in the future. Not a smart business choice. If that's where they are at this point, that was their prerogative. In the answer and counterclaims, defendants have disavowed all the contracts. Mr. Flocken has essentially admitted to defrauding Polaris with regard to his pledge equity collateral. My client doesn't want to do business with these folks anymore, right? There's no more deals. There's no more extensions. Like, we have an agreement. We have our rights. They've been in default. They've had a chance. Your Honor equitably gave them another 30 days. It's time to get someone else objective in control. A deal is a deal. The Big Sky case we cite at the motion in 12, agreed upon the receivership remedy and waived. And so a default equals receivership without the consent of defendants. That's pretty much it. The statute, specifically the Michigan Receivership Act, at Section 6, specifically supports this remedy under the contractual situation I've just summarized. That Section 6 also allows the court to appoint a receiver in the event of waste. I talked a little bit about the quiet title action before. I know Your Honor wasn't enchanted with that concept, so I'll just touch it briefly. But note that forgery motion is still before the judge in that case and is expecting a written opinion off a hearing from June 26th, which is still pretty scary. In addition, as I summarized, defendants are spending a ton of money on legal fees, raising, unfruitful affirmative defenses and counterclaims that they've now said the contrary in their own response. But everyone's spending a ton of money on this, when those resources should be going towards the receiver's efforts to gather all this and pull it together and see what's best for everybody. We have no interest payment. Evolutions is clearly insolvent. At some point in the prior motion, they admitted that they're improving their facility without Polaris's consent, which is another violation of the contracts. And in discovery, I asked them how they're paying for those new improvements, and they refused to answer. So I would presume that that's a bad answer and probably more waste. Finally, we have Mr. Flocken's fraud. They've admitted in discovery that he did not have the equity that he pledged to us repeatedly and that we relied upon repeatedly, which is material and just another type of waste, dissipation, impairment, so on and so forth. These folks can't be trusted, at least from Polaris's perspective, and it wants to use its right to appoint a receiver. So I think The concept of waste under the Receivership Act gives the court another basis. In the response, they write that Mr. Flocken's fraud is not the type of waste. I don't know how to respond to that, but I do think that that statement kind of confirms further that the Flocken thing is a real issue, which is questionable as to that sort of a type of admission, but I'll take it. And then let's talk equity. So, contrary to a lot of the soft representations in the response, the appointment of the receiver doesn't waive claims per se. If the receiver thinks there's a defense, the receiver is obligated to try that defense. And Poloris noted in his motion that it's happy to do that in a civilized fashion. The receiver has no intention of firing all 40 employees. I've spoken to this person. Our intention is to have him maintain operations of necessary employees and try to move this thing along as a going concern for the benefit of everybody. If Poloris wanted to, quote, shutter the business, we would use our foreclosure right. I have a personal property lien on everything there, and I could UCC sell that all and shut down the whole business irrespective of the real property issue. That's not what we are trying to do. It's best for everyone at this point that an objective seasoned business person get in there to assess the business, the quiet title action, this litigation, potential fraudulent transactions, and garner the assets and pull it all together to see what's going to be best for creditors and then equity holders. And I think that that's all evident from the papers, and I didn't see anything in the response that should cause the court to see it otherwise. And again, I really respected the 30 days to pay the interest decision. I haven't seen something like that before, and I thought it was very thoughtful. And, you know, they didn't pay it. So here we are. I'll yield to Mr. Ryan.
Okay, thank you. Mr. Elias, what's your position? You'll have to unmute, ma'am.
I have nothing further, Judge.
Okay, thank you. Mr. Ryan, response.
Thank you, Your Honor. This is a construction loan, which once there was a certificate of occupancy issued, there was supposed to be a refinancing and a mortgage set in place. At that time, these parties were talking about doing that mortgage before the wheels fell off the bus. So it was a construction loan. It's not like there's monthly payments that are willingly not being made or voluntarily not being made. The problem here is that there is a cloud in the title, and Evolutions, at its own expense, without assistance from Poloris, has engaged myself, my firm, in pursuit of that quiet title action to obtain to settle the title, and then we can obtain the financing that Poloris is owed in order to resolve this matter. That's why my argument is that a receiver is appointment of receiver fixes no problem at this point. They still don't have title settled in one party's favor or another. The quiet title action is before the Calhoun County Circuit Court. It is scheduled for its last deposition is July 10th. In 10 days. Mediation is on July 17th, and discovery closes July 19th. Unfortunately, we do not yet have a trial date, but we do have the potential of a mediation, perhaps resolution, who knows, this month, within 17 days, if we're able to resolve it. So, you know, what Mr. Sobchak doesn't speak to is the unclean hands argument that I raised here. You know, this is an equitable remedy that they seek, the appointment of a receiver. But they knew when it was actually their title agent that discovered the error in the title. Yet they went ahead and closed on this loan anyway. So it's a little disingenuous for them to say that they are somehow harmed. Granted, they're owed the money, but everybody knows that Evolutions doesn't have that type of cash. They never did. They had enough financing and enough investors to make themselves presentable to a mortgage lender and obtain a mortgage loan on this to satisfy the construction loan. But they're part of the problem here. It's not like they're an innocent third party here, Polaris. So although they want the receiver, and this is their third request for a receiver, it's not unlike fixing your wristwatch with a sledgehammer. It really doesn't fix any problem here. Yeah, and even if we were able to obtain quiet title on July 17th due to resolution of the mortgage or quiet title, and we would still need, Evolutions would still need up to 6 months to obtain financing. That doesn't mean they need the full 6 months and they'll obtain financing on that day, but it's not unreasonable to think that under the under the filing of a quiet title and obtaining clear title, that they would need sufficient time in order to market this thing to banks and other lenders in order to obtain the appropriate financing. So even if we were able to get a quitclaim deed at the mediation, it's not like we can refinance the next day. So, and then the other comment to make is that, the receiver needs to work. It's not like the receiver is going to be working for Polaris. The receiver needs to be employed and work for all the benefit of all creditors. But really what we have here, and I've pointed this out in the brief, we really have a lack of statement as to waste, which would be a need for the receiver. We've got a business that's up and running. It employs up to 40 people. It has engaged in litigation to correct this. It's doing all the things it needs to be doing. There's no allegation that it's squandering the asset or that it's ruining the asset or wasting the asset to the detriment of Polaris, which would be a justification for a receiver. So for those reasons, I do request that the appointment of receiver be denied here for the third time. Thank you.
Okay, thank you. Well, in this matter, obviously there are a lot of issues brought up by the defendants, but the one issue that they're not bringing up and they acknowledge is that they're not making payments in this particular matter. Again, court did previously, when we were in court, did provide an additional 30 days so that the defendants could get into compliance so that they would have the opportunity to continue to operate the business. And that's not happened. Not only has it not happened, they've not even attempted to make any payments in this matter during that particular time, nor have they stated today that they have any intention or any ability to make any payments in this particular matter. So the court does note there's a lot of issues. Obviously, those issues will be ferreted out as we proceed, but under the terms of the contracts, there is a contractual provision that provides the plaintiff with the opportunity to have a receiver appointed to avoid dissipation of what assets or waste. And also in this matter, court would look at the fact that they're substantially delinquent in making payments in this matter. And even when the court gave them an opportunity to, they did not cure it and bring the matter current. As a result, and pursuant to Section 6 of the Receivership Act, court does believe that the receiver is appropriate. The court would grant the motion for appointment of a receiver in this matter. The court will obviously have some conditions. The receiver cannot close nor sell the business without further order of the court. And the court would order that the receiver would proceed with and continue the quiet title action as well, so that that matter proceeds in, again, during the pendency of this action. Obviously, there are numerous other provisions in the court usually provides in a receivership order, and I can't delineate all of those now. I'm sure Mr. Sobczak, you probably had receiver appointed and know how lengthy those are. And what the court will do is, again, order that relief and that you submit an order for appointment of receiver under the notice of entry of the order, 7-day notice of entry in this particular matter. And anything else, Mr. Sobczak?
Yes, if I may, thank you, Your Honor. Initially, we appreciate the ruling. Firstly, we'll clean up the order. I frankly can't find the part that you mentioned, although it might be latent from the first draft. It is a lengthy document, so we'll give it another run through under the 7-day. I would note, statutorily or under Rule 2.604B, there is a time to object to the receiver himself, Mr. Bullock. We tried to shorten that to 3 days because I think there's good cause for it here. Can that 3 days run concurrently with the 7-day order? Because obviously it's important to us to get the receiver in place as quickly as possible. We have a holiday. I don't know if Mr. Ryan.
Have it be 7 days and run concurrent with the 7-day notice.
Got it. We'll do that. Next, I just would like to point out, there's these counterclaims, there's this answer. I think that they're essentially stepped on top of by some of the statements made by counsel today. Our response to the counterclaims is due on Wednesday. Would it be possible to stay those dates until the receiver is in place to evaluate the counterclaims, the answer, so on and so forth? Otherwise, we're just going to continue to file things based on, the prior guidance of defendant's leadership.
Mr. Ryan, do you have any problem with extending the dates for response to the counterclaim?
I don't have any objection to that. I do have another issue I want to raise, but.
Okay, well, we'll get to you.
In the order,
why don't you put in the order that the receiver would have, from the date of the order, would have an additional 28 days to respond.
Right. So just for the court's clarity, for instance, the counterclaims would be the receivers. So it would be 28 days for, frankly, I want to know if the receiver wants to pull the counterclaims or modify them or whatever before I try to move to dismiss them, just for judicial efficiency, et cetera, because I don't think they're meritorious. And I think given that they said they owe us the money, well, most of them are.
I'm not going to pass on that today.
Understood.
28 days to again respond to those.
Understand. And then lastly, I just want to point out that the stay, including here, only applies to the entity defendants. And so, we have personal claims against Mr. Lavender and Mr. Flocken, including fraud. As written, they still have to file their answer to my First Amendment complaint timely. And I want to make sure it's clear that we're not using company resources anymore for that legal representation.
That's fine. And obviously they're independent parties. So we haven't granted a receiver as to those independent individuals.
That's correct. That's all I had. Mr. Ryan, please.
Okay, Mr. Ryan, what did you want to bring to the court's attention?
The court may know that I filed a motion for summary disposition seeking the relief of arbitration, and that hearing has been scheduled before you for July 17th. So that is an issue that we should discuss now.
Okay.
Yeah, I believe that would fall under the 28 days. The motion's not meritorious. The receivers, the arbitration contract specifically exempts claims for us to enforce our security interests. We'll file a motion or a response, but I think it would be better suited to let the objective receiver evaluate those papers before we spend more legal fees on it.
Why we do this is put in the order, Mr. Sobczak, that we're going to extend the date on that to the 28 days as well to respond to the motion for summary disposition.
Yes,
And then Mr. Ryan can, at that time, your response, then he can notice that up if he chooses to do so after the 28 days.
So
the
we'll,
receiver can notice it up. Yes, that's right. Okay,
Yeah, we won't go ahead with that then, Mr. Ryan, on the 17th.
got it.
Okay. Ms. Elias, anything else that you have?
Nothing further, Judge. Thank you.
Okay, thank you. Well, get it submitted and we'll get it entered and proceed.
Straight away, Your Honor. Thanks very
Okay,
much.
have a good day. You have Niels on this?
Yes, I'm checking in with you.
Okay.
Please unmute.
All right,
All right, iPhone. First and last name, please.
Dylan Hall.
All right, Dylan. Let me,
10:30.
I'm in the wrong courtroom, I believe.
okay.
No, I think we're in the right courtroom.
Oh,
All right,
think
just letting you
supposed
know,
to
we do have 5 hearings scheduled at 10:30. I'm gonna place you in the waiting room. I'll bring you in as soon as we're ready to call your case, okay? Do not.
thank you.
Hold on, Samsung, I need to check you in.
Oh, okay.
Okay, your first and last name, please?
Casey Keach.
Let me see. All right. Yes. So Casey, just letting you know, we do have 5 hearings scheduled. So I'm gonna put you in the waiting room and I will bring you in as soon as we're ready to call your case. Please do not disconnect.
Okay, thank you very much.
First and last name, please?
Keith Welcher.
Okay, Keith, I'm gonna place you in the waiting room. I'll bring you
Hi.
in once we're ready to call your case. Please do not
Ma'am.
disconnect.
I have a question.
Yes.
Do you know about how long? Because I'm at work and I'm only on my lunch break.
Judge, do you want me to bring, I have that.
So I'm gonna have to just.
You have the plaintiff too?
Yes.
Well, we'll bring him in now.
All right.
Thank you, ma'am.
Yep. Marshall, I'm gonna place you in the waiting room. It'll be just a few minutes, okay?
Okay.
Calling case 2016-1070 DM Keith Welcher versus Casey Welcher. Today is Monday, July 1st, 2024 at 10:41 a.m.
Court will note that this matter is before the court on the defendant's motion to set aside referee recommendation in this matter. So the defendant, go ahead, you can proceed. I have read your motion, so you don't need to reiterate all that.
Okay, I was just, I don't really agree with how much child support he's wanting. I'm not working right now. And, I do have medical problems, as my doctor has stated, and I am working with a cardiologist right now. I actually have they're calling me later on today to do a heart monitor. So, those are things I'm going through right now. I also have, never mind.
Okay, well, I do note that you had stated in your motion that the doctor had wrote a letter saying about your medical condition, but there was nothing stated in that in the letter as to, again, diagnosis or prognosis as to your inability to work. And so a doctor can say anything, I'm treating the person for this condition or that condition, but if it doesn't go to the person's ability to work, we in the courts and the referee as a lay individual, we can't assume just because a person's under the treatment of a doctor that they're not able to work. So I don't know. I do note, Ms. Welcher, that you had ordered a transcript, and there was an excerpt attached. Page 3 of that was attached, but unfortunately, page 3 didn't tell me anything. So what you're going to have to do is, if you want the court to review the entire transcript, you're going to have to provide that to the court for the court to be able to review that.
When I went up to the courthouse, that's all they gave me, is what I sent to you.
I have no idea what they gave you, but again, a transcript of a hearing is more than one page. I can guarantee you that. So we need an entire transcript. And so what happens, the order will remain in place until further order of the court. And if you provide a transcript and the transcript would delineate that the referee made a factual or legal error, then the court will consider resetting the matter for a hearing. Otherwise, the order will remain in place.
Okay, when I sent it in, I got 4 pages that I sent in. I sent it to Mr. Welcher, you guys, and myself, and it is the full transcript is 4 pages.
Okay, all I can tell you is what the court did. I had 1 page,
I never got it.
and it was page 3, and that was it. So
It's with the whole packet.
you're gonna have to, well, you say that, I don't know how it got docketed or whatever. The court did not, I did not receive it. The clerk's office might have received it. I didn't receive it. Mr. Welcher says he didn't receive it. So you're gonna have to refile that so that we do receive it. And again, then, once we have the entire transcript, the court can review that.
Okay.
I got a question.
Go ahead.
Do you know when all this is supposed to start by chance? Like when she starts paying, or when this goes into
Well,
effect?
it would start, if you look at the order that the referee did, it tells where the order states the amount. Right up above that, it says effective date. That's the date it starts.
Sir, I didn't get it. That's why I'm asking you. I never got any paper, and then I called down there and the lady said that there was nothing in the computer.
You're
So
gonna
I
have
don't
to
know.
take that up with the clerk's office. We don't handle the files for the court. The clerk's office does, and I don't know what's in there or what isn't
I
in there.
figured you have a date on your paper in front of you that says when it's supposed to start.
I don't have it in front of me.
Oh, okay.
So you're
All
gonna have to get that, but it would state whatever the referee's order, the Uniform Child Support Order has an effective date on it as to when it's supposed to start.
Okay.
Okay, that will be the order of the court, and refile that, Ms. Welcher, and court will review it at that time and determine if there's any basis. Okay?
All right. Yes, I will.
Thank you.
I'll call up there. Thank you.
Yes. Please unmute. Marshall, please unmute. Calling case 2023-37 DP Marshall Moore versus Zandon Taylor. Today is Monday, July 1st, 2024 at 10:47 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court's office. This matter is before the court on the defendant's objection to the referee order. I note, Mr. Taylor and I reviewed the Uniform Child Support Order that was entered back on 6/6/24, that consolidated various cases and ordered a child support review in this matter. I guess, is that your understanding, Mr. Magnuson, that there's a review that's pending in this case?
That is my understanding, Your Honor, and I believe that should take care of any issues that are before the court at this time.
Well, that's what the court thought. So, Mr. Taylor, what I'm going to do is I'm going to allow the support review to continue. And I hope that that will resolve all issues concerning support. If it doesn't, you can file an objection or a motion at that time to whatever the referee decides, okay? I think it's premature for us to step in when the referee is doing a review.
Right. Okay. All right. I appreciate that, sir. Will I be receiving any mail about that?
You should. If you keep your address, current address on file with the front of the court, you'll get it.
Okay. Appreciate it.
Ms. Moore, is there anything that you have?
No, sir.
Okay.
As long
Well,
as he gets that taken care of.
Hopefully that takes care of it and we get it resolved. If not, then Mr. Taylor, you can bring the matter back before the court at that time.
I appreciate it, Your Honor.
Okay. Thank you.
All right.
Have a good day.
Thank you, Your Honor.
Niels, are you appearing on any other motions this morning?
No, I don't have anything else on my schedule.
All right, thank you.
Thank you.
Pepsi versus Meats.
Peace. Okay.
Please unmute Caitlin.
Good morning.
Michael, can you hear me? Please unmute. Oh, can you hear me?
I can.
All right, calling case 2024-10690 as Caitlin Apsey versus Michael Meese II. Today is Monday, July 1st, 2024 at 10:50 a.m.
This matter is before the court on the plaintiff's motion to set aside referee order. Ms. Apsey, I do note that obviously it's clear in your motion, you missed the hearing.
I did.
As a result, did not have any input, but notwithstanding that, what factual or legal error do you believe that the referee made at that particular hearing?
So I was more based off of our custody agreement because I wasn't able to state that I had Michael as much as I do have him, because I have him Monday through Saturday throughout the day because his dad works first and I wasn't able to state that I work seconds. So I'm not able to have him at night. Otherwise, I would be taking him more nights.
Okay. Well, at this point, I will tell you that the child support formula doesn't take into consideration times that you have during the day. It only pertains to overnight parenting time. So that in and of itself is not a sufficient basis to object. And so I don't see anything that you've provided today, nor in the motion, that would change the referee's determination, unless you have something else
I did have something else I wanted to bring into the fact as well. I had just noticed on one of the papers that it had said that Michael was getting unemployment insurance or unemployment pay, the $5,000 per year, when he had stated to me that he had made $80,000 a year. And if he only made $5,000 a month last year, that would imply that he made a $60,000 total sum for the year.
Well, we don't take that implies or inference or whatever. It's facts.
Okay.
And you have to establish by facts, not by what you surmise or by conjecture. So the court can't take that into consideration just because you think it may be applicable. You know,
All right.
at the time of the hearings, you have a right to bring up all your evidence in that at that time, and the referee considers it. Obviously,
Right.
the referee didn't consider any of that because you weren't at the hearing to bring that up. So it's not
Yeah, I
the
was accidentally
referee's
in the
fault.
wrong room. I was in this room instead of the referee's room by mistake last time.
Okay.
So in that sense, I was wanting to bring up the custody and the fact that I had tried to
ask Michael for more overnights and do a 50-50 state, and he said that that wouldn't work for him.
Okay, well, regardless, custody is not an issue today. The issue today was the support amount. If you have a sufficient basis to proceed on custody, you can file a motion and the court would then consider it at that time. But again, that's not before the court today.
Okay, and then with the state of my employment, because I had mentioned that on there as too, as my unemployment or my employment was up in the air. I am currently unemployed, so that was my only other problem with missing that last hearing.
Okay, well, you're gonna have to file, if that's the case and that's occurred since the hearing, you'll have to file a motion and address it, because again, pursuant to again, the opportunity to due process, that the defendant then would have an opportunity to respond, and then we could potentially have a hearing if necessary. But again, you can't bring these up at this time.
Right,
When the other side has no notice of what you're bringing up. So the court's going to deny your request to set aside the referee at this time, subject to, if you want to file additional motions, you can file that.
Okay,
Okay?
Yep.
Thank you both. You're free to go. Have a good day.
thank you.
Next case is Snyder versus Hillman. Plaintiff and defendant are both present. Please unmute. Calling case 2016-1285 DS Doriana Snyder versus Michael Hillman. Today is Monday, July 1st, 2024 at 10:54 a.m.
In this matter, the matter is before the court on the motion of, I think it'd be Ms. Snyder to opt out of the front of the court services. Ms. Snyder, I do note that front of the court objected, saying that the child is on Medicaid and getting food assistance as well. Is that accurate?
No, sir, that is not accurate. My son is not on Medicaid that I'm aware of. And if he was, then I wasn't aware of this.
Okay, let me ask Mr. Hillman. Mr. Hillman, are you aware of the child receiving Medicaid or food assistance?
He is not. So, and I verified this with DHS. I called them and made sure that they closed the case completely. He may have at one point, but I made sure that they knew that that case needed to be closed, and they took care of that for me. That would have been, I think it was Friday, I got a hold of them, the 28th.
Okay, well, let me tell you, under the motion to opt out, there's a provision, paragraph 3, that states neither party is receiving public assistance. There is no arrearage owed to any governmental agency that provided assistance. So I don't, again, if the child is off assistance now, I don't know if there is in fact an arrearage that's owed back to the state of Michigan. So what happens at this point, I cannot allow you to opt out until we know if there's an arrearage owed to the state of Michigan. So you'd have to get something through DHHS to confirm that there is no arrearage, et cetera, before the court would be able to grant your opt-out.
Okay, is that something I need to get, or what does that look like? I want to make sure.
One of you need to get it, or otherwise I can't let you opt out, because I can't let you opt out if there is in fact an arrearage owed to a governmental agency.
Understood.
Okay, so if you do have that, what we'll do is if you come up with that, then what you can do is you can just renew your motion and attach to the motion any statement or anything of that nature you get from DHHS confirming that there's no arrearage owed to the state.
What would the arrearage be, just so I understand? I'm not sure that either of us are aware of how that works or what they
Well,
are.
if there was assistance paid for and on behalf of the child, then the state would have, again, they would have a lien against any of those, if you want to call it a lien against any of the support payments. And what happens if they are accruing as a result of benefits being paid, they're accruing an arrearage of those benefits. So that would be it. If you get something certifying from the state agency that there is no arrearage, then I can allow you to opt out. Otherwise, I can't.
Okay, okay. So I will call them and verify what that looks like.
Yep.
and-
You're gonna
and
have to
that.
get something in writing, and if you get something in writing confirming that the child is no longer receiving benefits and that there's no arrearage, then we can grant it.
Okay.
Okay?
Your Honor,
Yes.
I just have a question. If I was unaware that my child was on Medicaid and, like we had an agreement that, you know, he has my son covered and I can put my son on my insurance and I wasn't aware of this. So I was just wondering how it falls back on me to pay the arrearages if I wasn't able to know that this was happening.
Well, because it was a benefit paid by the state. And they have a claim to reimbursement from those support amounts. And it's unfortunate you didn't know, but the fact is they still were making payments. And if they made payments, they're entitled to reimbursement. Okay?
It's interesting though, if I may, I have been paying insurance through my employer. Like I pay $400 a week for my health insurance for my son, for like everyone that's in my house. So I don't know. I guess I'm not sure how they would have been paying for him in the first place.
I don't know either, sir, but I don't have anything before me other than the objection saying that, in fact, he was on Medicaid and food assistance. It may be an error. And if you get something saying that it's an error and you provide what happens, you can provide DHHS with the confirmation that he was on your insurance all along, then there would be no reason to have Medicaid involved. That may take care of the issue. I don't know, but I don't have anything before me that's going to allow you to make that decision.
Okay.
So get whatever you can and then bring it back up and then we'll address it. Okay? Thank you. You're free to go. Have a good day.
Thanks.
Emily was on, she I just accidentally removed her, so she should. Oh, here she is.
All right, I'm here. Give me
All right.
let me
Dylan,
pull over.
Dylan, we're getting ready to go on the record. Calling case 2023-685 DM, Dylan Hall Senior versus Emily Hall. Today is Monday, July 1st, 2024 at 11:01 a.m.
This matter is before the court on the defendant's motion to set aside referee recommendation. And the substance with all in this matter, you state, and I quote, with lack of support in the area, it makes me skeptical as to the level of stability our children are going to receive. Is that the basis of your objection?
Yes, Your Honor.
Okay. And that's fine, but when you object to the referee, I cannot set aside a referee recommendation based on speculation as to what may happen. You have to demonstrate that the referee made a factual or legal error. And so what is the factual or legal error that you believe the referee made?
Well, Dylan is now back with his parents with our children. He no longer lives in Ohio.
Okay, and how does that impact the referee's decision?
Because of the fact that my children have been moved from house to house to house in the last couple of well, in the last year, I feel like the stability there is just not there. And I'm worried because of my son's behavior. It's gotten worse over the last year, being floated from here to there. And he needs to be in therapy, and I don't know if he is receiving therapy at this point because he's been bounced around so many times the last year.
Okay, well, if therapy is necessary, you always can file a motion seeking therapy. With that, Mr. Hall, what's your response?
Well, so we actually moved back to my mom's house because I'm actually having a relapse right now. So, and he's in therapy. He sees Jessica every Monday at 7:30. So, we just moved back with my parents so they could help me with my kids, so I could possibly receive the treatment I need.
Okay. Well, in this matter, again, Mr. Hall, why don't you provide Ms. Hall with, again, information as it relates to whoever the child's in therapy with, so she has that information. Provide her with the name, address, and phone number for that particular entity. But what?
I don't have their number.
Well, find it then, sir. Okay. If you take the child once a week, you should be able to know where they're at, get their card, get their phone number, and provide all of that to her.
It's actually in-home therapy, so I don't take them anywhere, sir.
Well, then you have to have some contact. In-home therapy, do they come into the home? Do they go by Zoom? What do they do?
I've got where the number she texts me off from. They actually come into the home.
Okay, when the person comes in the home the next time, get their contact information and provide that to the defendant.
All right, sir.
Okay, but at this point, the court doesn't have any basis to set aside the referee order. If that should happen in the future, Ms. Hall, you have a right to file a motion to modify the order, and you should do that if in fact you have a basis to do so.
So I do have a quick thing that I'd like to mention. In the referee's paperwork, it only grants me visitation with my daughter. I'm not really sure why that is. It says that I can't see Junior until summer of 2025, and then he's able to come visit every other week. I feel like him and I not being able to see each other has really strained our relationship and has very much affected his mental health.
And ma'am, I don't know why that's in there or what happened, but you'd have to, all I recommend is go back and get a transcript of that hearing, and the referee would normally explain in the transcript what the basis was for his determination, or it would be in his ruling, and then you'd be able to see what that is. But you haven't provided me with anything today that allows me to take the action that you've requested. So
Sir,
you can file a motion, or you can take other action in the future, ma'am.
So his ruling was to get him regulated on his meds and go to therapy throughout this summer so we can get him stable. Then we'll start.
That's fine. I'm saying based on what I have today, I don't have anything to, again, provide a basis to grant the defendant's relief. So the court will deny the motion at this time. So thank you. You're free to go. Have a good day.
Literally.
He's going to talk. Oh, okay. I said, okay, that's what. So as soon as Frank has ready.
Is this one negotiated too, 14?
It's negotiated, Mr. Aaron's.
It is, Your Honor.
It's a misdemeanor.
Yes.
Oh, just to the battery family violence?
Pointing a pistol, Your Honor.
Oh, okay.
I was just waiting for him to amend the indictment. I didn't see that email, but
I told her that we needed Judge House. Yeah.
Miss Sanders. Read.
cool.
What is that?
Hmm.
Brady, what is it?
I'll say it at first. Mhm. All right.
Sorry,
That's okay. We ready for this one?
we are.
All right, position 14, 23 SC 187656, Naya Stevens, STEPHENS. There's aggravated assault, possession of firearm, and battery family violence. This negotiated plea.
This is a negotiated.
Okay.
And just for the court's records, Judge, they don't actually live together, so we're switching the family violence.
Oh, okay. Ms. Stevens, while he's doing that, if you want to raise your right hand, do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth? Okay.
Ms. Stevens, could you state your name for the record, please?
Naya Stevens.
Oh, you keep your head down.
Oh, okay.
Yeah, that's the only time you gotta do that.
Sorry.
Could you repeat that because we can't hear you?
Naya Stevens.
Thank you. And just so you're aware, she's actually recording everything and typing everything you say, so you have to speak up and into the microphone. Right. And are you at this time under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
25 associates degree.
And so you're able to read, write, and understand the English language?
Yes.
Okay. Are you a United States citizen?
Yes.
And do you understand that you've been charged in indictment number 23 SC 187656 with one count of aggravated assault, one count of possession of a firearm during the commission of a felony, and third count of battery?
Yes.
And do you understand that you can either plead guilty or not guilty to these offenses?
Yes.
Have you had enough time to speak with your lawyer, Mr. Arrington, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with his services?
Yes.
And counsel, do you waive formal reading of the indictment and any and all defects therein for purposes of the plea?
We do.
And Stevens, have you been arrested on these charges?
No. I mean, yes. Sorry.
The reason I ask is because the state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
No.
And has your attorney advised you of the minimum and maximum sentence for each of the charges that you are actually pleading to?
Yes.
And do you understand that today you are entering what's called a plea of guilty, which means that the state will recommend the following sentence to the court. Count 1 on the aggravated assault will be amended down to pointing a pistol under 1611-102, which is a misdemeanor. Count 2, possession of a firearm during the commission of a felony, will be dismissed. And count 3, family violence battery, should actually be amended to just battery. Is that your understanding of the plea negotiations along with the other condition or special conditions that we've discussed before?
I thought we were just doing the one pointing the pistol.
I'm sorry. That's right. We were dismissing count 3 of the battery and just pointing a pistol.
Yes.
And I believe there was some, Mr. Arrington, correct me if I'm wrong, we're doing anger management, community service.
Yes, and she completed those already.
Yes.
And Ms. Stevens, I'm going to ask you on the record, are you forfeiting the firearm at this particular location?
Yes.
And you're just saying there is to be no contact whatsoever with Kayla Croy. That's Kaylacroy, the
Yes.
victim in this case. Okay.
And I just wondered, it was never her weapon anyway, but so she's fine with doing that, but it was never hers to.
I understand, Mr. Arrington, but for purposes of the plea.
Yes, sir.
And do you understand, Ms. Stevens, that the court is not required to accept the state's recommended sentence?
Yes.
And do you understand that the court has the right to sentence you to the maximum possible sentence on this charge, which would be 12 months in the county jail?
Yes.
Do you understand there are, if the court decides to order a sentence that differs from what we've negotiated here today, you have the right to withdraw your plea?
Yes.
And counsel, is your client going to ask for first offender?
No.
Okay.
Because with the reduction to misdemeanor.
Understood.
This
So
under Alfred or?
that's my next question. Are you playing under Alfred or are you just playing straight?
It would be under Alfred.
Okay. All right. Do you understand, Ms. Stevens, that this plea can be used against you to enhance sentencing and other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Okay. And do you understand that there may be other unfavorable consequences as a result of this plea, despite it's under Alford? For example, the ability to obtain employment in the future.
Yes.
And do you understand that you're waiving any and all defenses, including any mental health defenses, by entering a plea of guilty here today?
Yes.
And do you understand that you are giving up the following rights, which I'm going to read to you? Number 1, the right to a trial by jury. 2, the right to remain silent and not incriminate yourself. 3, the right to confront witnesses against you. 4, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case. 5, the right to the presumption of innocence. 6, the right to testify on your own behalf and present other evidence. 7, the right to subpoena witnesses and compel the production of evidence. 8, the right to have the charges against you proved beyond a reasonable doubt. And 9, the right to appeal if convicted of these charges after a trial. Do you understand that you are giving up those rights here today?
Yes.
Do you understand that you only have a limited right to appeal this conviction, specifically for a misdemeanor charge, which is what you're pleading to here today? You have 12 months from today's date to file what's called a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes.
Okay. So how do you plead to the one charge of pointing a pistol at another in indictment number 23 SC 187656?
Guilty.
And
No, it's doing under all.
Oh,
Under
well,
North Carolina versus Alford, yes.
yes. Sorry.
That's okay.
and are you pleading guilty because you have decided that it's in your best interest to do so?
Yes.
And are you aware that even if you do not admit guilt under Alford versus North Carolina, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
She's standing silent at Alford.
Oh, sorry, my bad.
That's okay.
We've thought about
I
it.
forgot a little
Yeah.
bit.
Thanks, Judge.
All right.
And so is the plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
And counsel, are you stipulating to a factual basis in this case?
We are.
And Judge, the defendant has no criminal history whatsoever.
All right. Anything, Mr. Arrington?
No, Judge, we would just ask the court to accept, the negotiated plea. She has completed, anger management and community service and a gun safety course. And so, we would just ask the court to accept the plea and, I believe that it was without probation, but to the extent that the court would like probation, we would ask that the probation be terminated upon completion of those.
No objection from the
Okay.
state judge.
All right. We'll take that under Alfred. I feel it's been given freely and voluntarily. Best of luck to you, Ms. Stevens.
Thank you.
Thank you, Your Honor.
40.
I think it
or
was 40.
50. Yeah, 40.
I think so.
We, yeah, we do. I can grab it.
Yes, I can email it to you. Yeah, absolutely. Thank you. That's all that we have, Your Honor. May we be excused?
Absolutely. Have a good week.
You too.
Who do we have next? Which one will we do next?
I think I'm ready for Miss Finnewan and Mr. Hall. So let's, yeah, we're doing police step. Okay, come on, let's go. Y'all had all morning. Thank you. Because it was supposed to be the other day. And that's what you're doing. You asked me to bring her over today. Okay. But she's not getting food today. So what is your thought? She's gone, what's in the way? He can go on the trial down there.
I don't know if this helps, Mr. Luemba's ready.
Yeah.
I'm just not sure if Mr. Crail is on.
I have not given him the Zoom link. You have it, if you wanna,
Give me send it to him.
please.
I can.
Thank you.
Yep, I'll send it right now.
Okay.
Actually, I'm just gonna take a picture of him and send it.
Technicals my business, might be excused.
Yes, ma'am.
Thank you.
You didn't even have business.
I thought I had.
Like, I'm ready.
Didn't have it.
I don't want to talk. What position is this? Great question.
This is well.
What position is this?
But we've got a,
8, thank you. 8, 9, and 10.
yeah. The 3 co-defendants.
Excuse me?
What is your name?
Mohammed Luwamba.
It's not Krell.
No, that's not Krill.
I don't know faces or names.
Oh, yeah, no, that's not Krill. I just sent Krill the.
Isaiah Burt.
I'm sorry, what? You've got.
I got Burt, Isaiah Burt.
Oh, you want to do that? Regular.
I got it.
Yeah, I just sent him the thing. So. What's his name?
Isaiah Burt.
Oh.
5, 6, and.
Oh, I got the wrong case.
Yeah. I thought Jerry's Wells, well, no. I know. No, not bad.
Okay, so it's,
The mall case too. Sorry, my bad. So we're doing Mr. Burks.
Yes.
Are any other co-defendants taking please?
As far as I know, but
Mr. Norman, he came in here. What about, where'd he go?
Don't worry about that.
Or Miss Hemingway? What about your guy? You're on for Keontae Smith?
Further notice to them. That they had an opportunity, they missed their window. I have a good day.
And judges will be unnegotiated.
Okay. And so you don't know if Mr. Smith's gonna plead, Miss Hemingway? Okay. All right, so this is non-negotiated?
Correct.
Yes, Judge.
All right, so this is 23 SC 187063 Isaiah Burke, ISAIAH Burke. We got trafficking in illegal drugs, VGSA, possession of controlled substance in Schedule 1 or 2 with intent to distribute, possession of a firearm during the commission of a felony, and receipt, possession of, or transport of a firearm by a convicted felon or felony first offender. Go ahead.
Thanks, Judge. Mr. Burt, will you raise your right hand, please? Do you swear or affirm the testimony you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down. State your true, correct, and legal name for the record, please.
Isaiah Burt.
Are you at this time under the influence of any alcohol, drugs, or medication?
No.
Okay. Is there any medication you normally take that would affect your ability to understand what's going on here today?
No, sir.
And how old are you? How far have you gone in school?
36. I've graduated from college. I have an associate's degree.
And are you a United States citizen?
Yes.
And you heard the indictment that the judge read. Do you understand that you have been charged with those offenses?
Yes.
And do you understand that you have the right to either plead guilty or not guilty to those charges? If you plead not guilty or remain silent, you can receive a jury trial.
Yes.
And have you had enough time to speak with your lawyer, Mr. Luwemba, about all the facts and circumstances known to you regarding the charges in the indictment, including any potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with his services?
Yes.
And counsel, do you waive formal reading of the indictment and any and all defects therein for purposes of this plea?
We do.
And Mr. Burt, have you been arrested on these charges?
Yes.
The reason I ask is the state is unaware of any outstanding warrants related to this particular charge or these charges. Do you or your attorney have any knowledge of any other pending warrants for these charges?
No. No.
And has your attorney advised you from the minimum and maximum sentence for each of the charges that you are pleading?
Yes.
So do you understand that you are entering what is called a non-negotiated plea? The state will make a recommendation, your attorney will make a recommendation, and that decision is up to the judge.
Yes.
And you have heard the offer offered by the state in this case, correct? And do you understand that the court can impose any sentence authorized by law, including a higher sentence than is recommended by the state, up to the maximum sentence on each charge in this indictment?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence? Do you understand that?
Yes, sir.
And do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
And are you asking for a first offender treatment or conditional discharge for this plea?
Conditional discharge.
And Mr. Burt, have you ever pled guilty or nolo contendere under the conditional discharge statute within the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the conditional discharge statute?
No, sir.
Has your attorney explained the conditional discharge statute to you?
Yes, sir.
So you understand that if you complete the recommendations that are given to you by the court, that you can honestly say you've never been that conviction will be discharged.
Yes.
And do you understand that this plea can be used against you to enhance sentencing in other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
And do you understand that neither the court nor the attorney or the district attorney's office or your attorney has anything to do with paroles or the Department of Corrections or the Board of Pardons and Paroles? No one can guarantee parole, no matter what anyone has told you in this case.
Yes.
And do you understand by pleading guilty to a felony, assuming that you do not, while you're doing the conditional discharge, you cannot use, possess, transport, or be near a firearm while you're doing this particular sentence? You understand that?
Yes.
And do you understand that there may be other adverse or unfavorable consequences as a result of this plea conviction? For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. You understand that?
Yes, sir.
And do you understand that by pleading today, you are waiving any and all defenses, including any mental health defenses, by entering a plea of guilty here today?
Sir.
And by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not to incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you, or court-appointed counsel if you cannot afford counsel at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond reasonable doubt, the right to appeal if convicted of these charges after a trial. And do you understand that you're giving up those rights here today?
Yes, sir.
And do you understand that you have only a limited right to appeal this guilty plea conviction here today?
I mean, excuse me?
A limited right to appeal here today.
Sir.
Okay. So just your attorney can explain that some more to you. You also have 4 years from today's date to file what's called a habeas corpus petition challenging the voluntariness of this guilty plea. Do you understand that?
Yes.
So under indictment number 23 SC 187063 to the charge of trafficking, how do you plea?
Guilty under Alfred E, North Carolina. V versus.
Okay. Has anyone, or let me put it this way, is it your decision to waive these rights and enter a guilty plea because you have decided that it's in your best interest to do so?
Yes, sir.
And so you are aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial.
Yes, sir.
Okay. And is this plea freely and voluntarily given with full knowledge of the charge and charges against you?
Yes, sir.
As for the rest of the charges on the indictment, how do you plea?
Guilty under Alfred V, North Carolina.
Okay. And has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
And judge, just for a factual basis, should this case have gone to trial, the state would be prepared to show that on August the 2nd of 2022, Atlanta Police Narcotics Unit executed a search warrant at 3810 Camelton Road, Southwest Atlanta, what is known as a Deluxe Inn, on room number 124. Once 3 controlled buys had been done at that room on previous occasions by the narcotics unit by undercover confidential informants, at which point officer secured this particular warrant, did one more controlled buy as of that date. Immediately after that controlled buy, no one left or had left or entered the room. After that controlled buy, Atlanta Police SWAT team stormed the location and found Mr. Isaiah Burt, Mr. DeAndre Roster, and Mr. Keontae Smith within the room. Upon search of the room, officers located approximately 176 grams of suspected powder cocaine, along with marijuana and 5 firearms. After which, none of the defendants resisted arrest. All were taken into custody. Drugs were tested and came back positive for cocaine. And subsequently, the defendants were charged accordingly. Your Honor, the state is unaware of any prior felony convictions for this defendant. The state is asking for the statutory minimum on the trafficking charge, which is 10 years to serve 1 in custody, followed by 5 years consecutive suspended on the firearm charges, and the other drug charge to run concurrent. The state is also asking for Mr. Burt to have no contact with his co-defendants, to stay away from the incident location. Again, that location being 3810 Camelton Road Southwest, room number, the Deluxe Inn in Fulton County. And to have no weapons, be random to random drug screens, and no alcohol or drugs without a prescription.
All right, go ahead.
Good morning, Judge.
Good morning.
Good to see you. Haven't been in front of you in a while.
I know, right? It has been a while.
Yeah, it's been a long time. So myself and Mr. Marquez are pretty close. They're asking for 10 to serve 1 in custody. We're asking for that 1 to be probated along with the rest of the sentence. Let me tell you why, Judge. Mr. Burt I have had hundreds of clients. He's one of the most impressive ones I've ever met in my life. Mr. Burt has 3 children. He has an 18-year-old son by the name of Keenan, just graduated from high school with honors, headed to Fort Valley State. He has a 22-year-old daughter named Tabrika. She's working, and a 14-year-old daughter named Azaria. Now, that 22-year-old daughter was most impressive about Mr. Burt. He's only 36. He had that daughter when he was 14 years old. Him and the mother are still together, have 3 kids. They're married, got married at 22, graduated from North Georgia Technical College with an associate's degree in electrical construction. He's currently a rebar professional. He builds houses, he works on buildings, really good at working with his hands. And because his son just graduated, in order to supplement his income, swallowed his pride, and he's working for Flagger Force. He's the guy that's on the side of the road, twirling the signs, telling you to go to the nearest cell phone place to go get your cell phones, because he wants to make sure that his son has extra money. Now, he could have done what a lot of people do and been an irresponsible 14-year-old dad, or said, hey, I'm raising my kids, I want to get back to doing the negative things I was involved in, but he didn't do that. This incident happened August 7th, 2022. He's been 20 months incident-free, 20 months working, doing what he's been doing his entire life, raising his kids. I understand that the state is asking for a year, but I don't think that it would promote justice or any interest in society to have Mr. Burt do a year and take him away from his 14-year-old daughter, 22-year-old daughter, and 18-year-old son who needs his father. He's about to start college. Now, he did take this plea under Alfred v. North Carolina, because I did explain to him that when you're practicing law, the predictable outcome is most likely better than an unpredictable outcome, and an unpredictable outcome and going to trial God forbid we lost, even though we would be willing to fight the case tooth and nail, we'll be talking about a lot more. So we felt that this was in his best interest. We're not going to get into the facts and circumstances of the case, but I will say he's the least culpable of this entire situation. So because of those factors, Judge, and the fact of his very, very limited criminal history, we're asking that same thing that the state is asking for, but we're just asking that the entire sentence be probated. He is granted the conditional discharge and let him just continue doing what he's been doing for the past 20 months, or really for his entire life, being a great dad, raising his kids, and just being there for his family. And none of his kids have made, I don't want to say mistake, but have made the incident that he made in being a really young teen parent. So none of his kids has done that. So he let them know the pitfalls of having children so early. So we just ask that you just accept what we're proposing as opposed to what the state's proposing. We're only 12 months off, and let this man get back to his family and being a positive, productive member of society.
Oh, she's one.
I don't have it. I'm sorry. I thought we had it. I don't have the indictment.
Anything reduced or no price on here?
It's a tier 1 trafficking because it was 76 grams total
Yeah.
that were actually tested. So the minimum is 10 years, but jail time's up to the
What's today's date? 29.
And just for clarification, Mr. Lumba, are you agreeing to an asset forfeiture of the weapons?
Yes.
Okay, just check.
The guns. Asset forfeiture of the guns.
Yeah. Yeah, absolutely.
It's not right there.
Hold on one second. Going out here. Oh.
Relate to me what you're missing, so I think I just sent it to you. Yeah. But I don't. So what are you missing? Phone records, that's just linked to that. And then the firearms are still pending. Yeah. So they should be in that Dropbox link now. And I'll go back. That's extraction. I'll follow up with them. Before I just send them, I will counsel. Yeah, that's what it is. There was anything else. So, I didn't steal it. I don't know how it's not back in. Where's the things? But I don't think I got it. No, I think you're right. But that's all that goes on. So she told me 30 to 45 days. I'll make sure that Kelsey or I follow up. Okay, I would make sure I do. So, no, I appreciate it. I'll make sure it's there. But what do you? That's that. I need 45. Whatever y'all want. We're not in a rush at this point. Yeah. We are fine. Right. But, so physics. Let me. Yeah.
I come back and I said. Yeah. That's just, Mr. Norman. Have a seat, darling. Go, you go to seat. Can I go back? Wait, back here. Yeah, I don't know. Mr. Abate.
Abate? She, right? Client comes to us.
Well, let's see, are we ready on Jadarius Wells?
There's co-defendants in the case you want to put together.
Oh, the co-defendants. Oh, I know there were co-defendants on Jadarius Wells.
Yes, Your Honor, and Ms. Andrews and Mr. Wells.
Oh, okay. Do they need to get together and talk? Or do you want?
Harder.
We're going to remain seated.
All right. Do you want to go ahead and take Mr. Lewis's case?
Yeah.
Wow, we come back.
With Miss Harder and
We're gonna stand by and come back on that. And all three maybe have,
I'm waiting for Ms. Hemingway, co-defendant.
yeah.
Mr. Wells. If you're. Okay, great. So you're ready as well?
Mr. Lewis is on.
So, well, I think we're just waiting for Ms. Hemingway. She stepped out. Fine, Your Honor.
Client comes to us.
Well, let's see, are we ready on Jadarius Wells?
There's co-defendants in the case you want to put together.
Oh, the co-defendants. Oh, I know there were co-defendants on Jadarius Wells.
Yes, Your Honor, and Ms. Andrews and Mr. Wells.
Oh, okay. Do they need to get together and talk? Or do you want?
We're waiting for Ms.
Yeah, Hemingway.
and Ms. Andrews. I'm here for Xavier Wells. Mr. Craig Lewis is here for, Mr.
Yeah, okay.
Yeah,
I'm sorry. I know you said that and I was completely just keep thinking about this other one.
Yeah, so she's back now. We can go forward. We can
It's-
see.
Ms. Hemingway, do y'all want to go ahead and do Wells, Andrews, and the other Wells? While everybody's talking to their respective client in the other case? All right.
Please be mindful not to identify shit, and otherwise it comes up on the record as she.
Correct. I remember.
All right, so we can get Jadarius Wells, India Andrews, and Xavier Wells. Which one are you? Jadar, come on up. Okay, come on up, sir. And then we got, so is where's Andrews? Oh, okay.
There's
So
also
Mr.
5
Jadarius Wells, can you see your
Yeah, with
attorney on there?
Yes, ma'am.
Mr. Lewis, okay.
5 years suspended. Yeah, but these are what the court does.
Gonna ask questions. So Mr.
Yeah, while they're talking to their respective.
Make sure you speak loud enough because.
That one's not going next, right?
Is this negotiated?
Let me go back.
We have to have
Yeah,
everything
no.
on the record.
Yeah,
Are
if
these
you would just
negotiated?
let me know, Adam.
They are, yes, Your Honor.
Okay,
Because what I can do is I can switch it to one defendant having it, not the other.
so we don't know where
I just saw her outside.
Ms. Andrews?
Yes, she's coming in.
Yeah,
Carol, can you hear me?
I can, thank you.
Okay, just checking.
Waiting on Miss Andrews.
Yes, I heard.
She go to get her. How's it going, Mr. Lewis?
It is going, Judge. You know, I'm doing triple duty with Judge Robert Mack. I just walked out of his room and I'm still in front of Parker, and now with you. So.
All right. Well, tell Mr. Mack I said hello.
I will. He's
that
in
Miss
his
Andrews?
jovial years.
Sure. Ugh.
Ms. Woods, number 13 is here, Ms. Rice. She said she's been here. I guess she just missed it when we first called, so. Although we're further noticing it
Yeah.
to trial.
Okay.
That will be on the trial calendar, but I mean, I mean, to the 2-hour call.
Okay.
And she be.
Come this way. Nothing's gonna come on. He's got a gun. Ain't nothing gonna happen. So what we'll do is, as long as you can be near a microphone when she talks, I guess. Or if once y'all once. So is it Mr. Wells or which Mr. Wells is it?
Refer to my client Judge by his first name, Jadarius, and that'll keep the.
Oh, okay. Is it Jadarius Wells? Miss Hemingway?
No, I have India Andrews.
No, I'm talking about which one is there an issue with?
I'm gonna be the issue. Xavier, my name is Xavier.
Okay, there you go. I mean, I don't
There we
care.
go.
I'm not saying it for sure is. I just want to know. So what about that? If, do you want to stand up there? He's on the other side. Is that okay? She's speaking really low and I left my hearing aids at home. So you're going to have to dig deep down and
Or have her stand closer to that microphone.
yeah, or pull that down maybe. Yeah. You're going to have to speak really loud. Try it.
Okay.
No louder.
I need to hear you for the rest.
Yeah, we can't even hear you, even with the microphone.
Okay, I'm sorry.
No, keep going louder.
Way louder?
You have children?
Yes.
Act like one of them's over there in the corner misbehaving. Okay? All right. So we're gonna do Jadarius Wells, 23 SC 188045, 2 counts of aggravated assault, 1 count of possession of firearm by a convicted felon. And we have India Belinda Andrews, 23 SC 188045, 2 counts of aggravated assault, and 1 count of possession of firearm during the commission of a felony. And then Xavier Marquise Wells, 23 SC 188045, 2 counts of aggravated assault, and 1 count of possession of firearm during the commission of a felony. Let's see, Mr. Jadarius Wells, can you raise your right hand? Do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes.
All right. Miss Andrews, can you raise your right hand? Do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, ma'am.
Can you hear Miss? Okay. And then Mr. Xavier Wells, if you can raise your right hand, do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, ma'am.
All right. Go ahead.
All right, thank you, Judge. And we'll do this in order. I will call your name and you will answer the question accordingly. Please answer yes or no into the microphone so the court reporter can hear you and she's actually typing this. All right,
Excuse me, Your Honor, before Mr. Prosecutor goes forward, Mr. Prosecutor, you did get the GCICs in front of you?
I do.
Okay, very good.
All right.
I think all of these are going to be first offender, please.
They all are first offender, please.
Okay.
I
Is that
heard
correct?
the judge say, yes, but I heard the judge say something about possession of a firearm by a convicted felon.
Oh, I'm sorry. Possession of firearm during the commission of felony. I'm
Okay,
sorry.
now we can go forward.
There we go.
All right.
Okay.
Thank you, Mr. Lewis. You always keep me on my feet.
All right. We'll start with you, Miss India Andrews. Are you at this time under the influence of any alcohol, drugs, or medication?
No.
And Mr. Jadarius Wells, are you under the influence of any alcohol, drugs, or medication?
No.
And Mr. Xavier Wells, are you under the influence of any drugs, alcohol, or medication? Okay. And Miss India Wells, how old are you and how far have you gone in school?
Yeah, Andrews.
I'm sorry, India Andrews. Miss Andrews.
I'm in college.
Okay. How old are you?
21.
Okay. And what year of college are you in?
I just currently enrolled again. I just currently enrolled again.
Are you a freshman, sophomore, junior, freshman? Okay.
And are you a United States citizen, Ms. Andrews? Okay. Mr. Jadarius Wells, how old are you and how far have you gone to school?
I'm 22 and I received my high school diploma.
Okay. So you can read and write the English language.
Yes, sir.
And Mr. Xavier Wells, how old are you and how far have you gone in school?
23 years old, high school diploma.
Okay. And you can read and write the English language. Okay. And Miss India Andrews, are you a United States citizen?
Yes, sir.
Mr. Jadarius Wells, are you a United States citizen?
Yes, sir.
Mr. Xavier Wells, are you a United States citizen?
Yes, sir.
And understand, do you all three understand that you have been charged with the following aggravated assault, or 2 counts of aggravated assault and 1 count of possession of a firearm during the commission of a felony? Miss India Andrews, do you understand that?
Yes, sir.
Mr. Jadarius Wells, do you understand that?
Yes, sir.
Mr. Xavier Wells, do you understand that? And do you understand that you have the right to either plead guilty or not guilty to these charges? If you pled not guilty or remain silent, you may receive a jury trial. Miss India Wells, do you understand that?
India Andrew.
I'm sorry, India Andrews, do you understand that?
Yes, sir.
Okay. Mr. Jadarius Wells, do you understand that?
Yes, sir.
Mr. Xavier Wells, do you understand that? Miss Andrews, have you had enough time to speak with your lawyer, Miss Hemingway, about all the facts and circumstances regarding the charges in this indictment, including any potential defenses in this case?
Yes, sir.
Okay. And Mr. Jadarius Wells, have you had enough time to speak with your lawyer, Mr. Crail Lewis, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Mr. Xavier Wells, have you had enough time to speak with your lawyer, Ms. Charlotte Carter, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
You gotta let him finish talking.
Sorry. Go ahead.
Yes, sir.
Thank you. And Ms. India Andrews, do you need more time to discuss the case with your attorney?
No, sir.
Okay. Mr. Jadarius Wells, do you need more time to discuss the case with your attorney?
No, sir.
And Mr. Xavier Wells, do you need more time to discuss the case with your attorney? And are you satisfied with your attorney's services, Ms. India Andrews?
Yes, sir.
Okay, Mr. Jadarius Wells?
Yes, sir.
And Mr. Xavier Wells? And counsel for India Andrews, Ms. Hemingway, do you waive formal reading of the indictment and any and all defects therein for purposes of this plea?
Yes, I do.
And Mr. Lewis, same question to you, sir. Do you waive formal reading of the indictment and any and all defects for purposes of this plea?
On behalf of Jadarius Wells, yes.
Thank you. And Ms. Carter, on behalf of Xavier Wells, do you waive formal reading of the indictment and any and all defects therein for purposes of this plea?
So waived.
Thank you. And I will do this way. I will read the question one at a time, and then I will ask you each individually of your answer. Have you been arrested on these charges, Miss India Andrews,
Yes, sir.
Mr. Jadarius Wells,
Yes, sir.
Mr. Xavier Wells? Okay. The reason I ask is because the state is unaware of any outstanding warrants on these charges. Do you or your attorney know of any outstanding warrants related to these charges? Miss Andrews?
No, sir.
Okay. Mr. Wells?
No, sir.
And Mr. Xavier Wells? Okay. And do you understand that you are entering what is called a negotiated plea of guilty, which means the state will recommend or make a recommendation to the court along with your attorney? Miss Andrews, do you understand that?
Yes, sir.
And Mr. Jadarius Wells, do you understand that?
Yes, sir.
Mr. Xavier Wells, do you understand that? And do you understand that the court is not required to accept the state's recommended sentence? And the court could sentence you to the maximum sentence allowed by law. And if the court does decide to order a sentence that differs from the negotiated plea you were expecting today, you have the right to withdraw your plea of guilty. Miss India Andrews, do you understand that?
Yes, sir.
Mr. Jadarius Wells, do you understand that?
Yes, sir.
And Mr. Xavier Wells, do you understand that? Okay. And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence? And you are not allowed to possess or use a firearm while on probation. Miss India Andrews, you understand that?
Yes, sir.
Mr. Jarius Wells, you understand that?
Yes, sir.
Mr. Xavier Wells, you understand that?
Sir.
And are you asking to be treated as a first offender under the provisions of the First Offender Act, Miss India Andrews?
Yes, sir.
Mr. Jadarius Wells?
Yes, sir.
And Mr. Xavier Wells?
Yes, sir.
And has any one of you either pled guilty or nolo or ever been convicted of a felony within the state of Georgia or any other jurisdiction, been sentenced for any crime, felony, or misdemeanor under the First Offender Act? And has your lawyer explained the First Offender Act to you? Miss India Andrews? Yes or no?
Yes.
Okay. Mr. Jadarius Wells, yes or no?
Yes.
No,
And
he has not been convicted, nor has he ever pled to, speaking of Jadarius Wells, a felony anywhere in the state of Georgia or ever pled to anything under the First Offender Act, misdemeanor or felony.
And Mr. Lewis, have you explained the First Offender Act to your client, Mr. Jadarius Wells?
Yes, I have.
I'm sorry, Mr. Xavier Wells? Yes or no?
No, sir.
Your lawyer has not explained the First Offender Act to you?
Oh, yeah, she explained. I'll say I've never been a convicted offender.
Okay. And so you are aware if you violate the terms of your first offender sentence or commit a new sentence while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment. Miss India Andrews, you understand that?
Yes, sir.
Mr. Jadarius Wells, you understand that?
Yes, sir.
Mr. Xavier Wells, you understand that? All right. Just so you understand that in the future, this plea can be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts. By pleading guilty here today, even though it's under the First Offender Act, while you're on felony probation, you cannot use, receive, possess, or transport a firearm or use a firearm in a crime, or you will be guilty of a felony, which could carry a sentence of 1 to 15 years in prison. And there may be other adverse or unfavorable consequences as a result of this guilty plea here today. For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, and the ability to obtain employment. Do you understand that you're waiving any and all defenses, including any mental health defenses, by entering a guilty plea here today? Miss India Andrews?
Yes, sir.
Mr. Jadarius Wells?
Yes, sir.
And Mr. Xavier Wells?
Yes, sir.
And do you understand by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not to incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Miss India Andrews, do you understand you're giving up those rights?
Yes, sir.
Mr. Jadarius Wells, do you understand you're giving up those rights?
Sure.
Mr. Wells, do you understand you're giving up all those rights? And do you understand that you have only a limited time to appeal your guilty plea conviction? You have approximately 4 years from today to file what's called a habeas corpus petition challenging the voluntariness of your guilty plea. Miss India Andrews, do you understand that?
Yes, sir.
Mr. Jadarius Wells, do you understand that?
Yes, sir.
And Mr. Xavier Wells, do you understand that? So how do you plead to the charge of aggravated assault and indictment number 23 SC 188045, Miss India Andrews?
Guilty under Alfred.
Okay.
It's under Alfred.
Under Alfred.
Okay.
And Mr. Jadarius Wells, how do you plead to the charge of aggravated assault and indictment number 23 SC 188045?
Good.
Under Alfred.
Also under Alfred. And Mr. Xavier Wells, how do you plead to the charge of aggravated assault under indictment number 23 SC 188045?
Guilty under Alfred.
And how do you plead to count 2 aggravated assault, Miss India Andrews
Under Alfred.
and Mr. Jadarius Wells
Guilty under Alfred.
and Mr. Xavier Wells?
Guilty under Alfred.
How do you plead to count 3, possession of a firearm during the commission of a felony, Miss India Andrews,
Guilty under Alfred.
Mr. Jadarius Wells,
Guilty under Alfred.
Mr. Xavier Wells?
Guilty under Alfred.
And has anyone forced, threatened, or promised you anything? Oh,
1 second. Oh. Okay, hold on 1 second. Everybody sit down. Wait for me. Okay, I'll reach you the back. Stop saying my name.
is everybody okay? Everybody okay?
I don't know.
Okay.
I'll text you where to go.
Well, you know, that's I'm the big player. Yeah, she brought me to court. You know, he called me, folks, talking about he gonna call me. Don't be, me and my cousin tried to challenge. Oh, well, okay, y'all. Dang. Court, bro.
I was I know you have to like, put all those paragraphs, stuff, and I have to make sure everybody's okay. I used to have.
10 years probation, straight probation. Mhm.
Hey, Frank, your conversation is live on the screen.
I know.
Okay.
Printed, I got it ordered, and then I'm still going to do it tomorrow.
So did you all run Judge Schwall away?
Well, he was in the middle of a civil trial. I'm just not sure what's going on back there.
Oh, okay. I walked in the middle of one in Judge Mack's courtroom. It's just so
No,
confusing today.
You're good. You're good.
I would be hoping that's not on my side.
And I don't want. By the way, it's a very big deal. Officers, right? They constantly like my house. Where are you? I live real close.
I've heard you talking about that. At least talking about myself.
Yeah. And Miss Hall's over there as well. Miss Hall's a little bit closer to me. Actually. She's right off. I live on. But I take the East Point train. That's my choice. What's that? Oh, no, it's Sergeant Burton. But the deputy should know about it.
I told you 5 people.
I hope everybody's okay.
That's what the only thing that we can- That's what I'm saying. You know, okay, I just, I didn't look at them. Yeah, I'm sure. It's bad. Yeah. No, I'm not saying you are. I'm just saying, I do remember that case. It's just, I didn't realize. They found the trials. Oh, yeah, so that's when you email.
I'm not leaving.
Right.
Anyway.
No.
Great.
We've got already.
Great. And because I would be great.
No, I was thinking.
And
No, yeah.
when I got out of college,
He's gonna take.
I was fine.
No, you good. I don't want.
All right, sorry about that, y'all. That was, did you hear on the radio?
You good, you good.
Okay. No, he was just talking to me. Oh, but that's why, yeah, he was probably, they said Kathy's driving him while they're helping him, yeah. I'm like, what? Yeah, I know it. Cause you know, call me ASAP. Yeah, so we'll keep him in our thoughts and stuff. Yeah, but so he's on the way to
Well,
be fine. Okay, I apologize. There's a, come on back up. I'm sorry. Miss Carter, Miss Hemingway, if y'all want to come up. Y'all want to come here, I'll tell you what. Oh, yeah. I'll let y'all know when I'm not, but that's, sorry, so that's reason I had, when he said ASAP, usually it's not ASAP, but this time it was really ASAP. So, all right,
Anybody can text me with that.
okay.
yeah, I will.
Okay, continue. And I do apologize. It was an emergency, so.
Not a problem.
Last one was and then enforced that they're.
Thank you. So I'll repeat the question. Has anyone forced, threatened, or promised you anything to get you to plead guilty? Miss India Andrews, Mr. Jadarius Wells, Mr. Xavier Wells.
No, sir.
Is it your decision to waive these rights and enter a plea here today because you have decided that it's in your best interest to do so? Miss India Andrews,
Yes, sir.
Mr. Jadarius Wells, and Mr. Xavier Wells.
Yes, sir.
And I'll just ask, Miss Hemingway, do you stipulate to a factual basis in this case?
Yes, I do.
And Miss Carter, do you stipulate to a factual basis in this case?
Yes.
And Mr. Lewis Crail, do you stipulate to a factual basis in this case?
Yes.
And the state's recommendation is going to be 10 years probation on count 1. Count 2 will merge, and count 3, I believe that can be
Suspended.
5. I think it's 5 suspended.
Okay.
That's right.
Correct. There is a weapon forfeiture in this case, or asset forfeiture. There is to be, do not return to the West End Mall, located at 237 Lawton Street, Southwest in Fulton County. Sorry, Lawton, and that's Lawton Street, Southwest. Thank you. There is to be approximately $2,500 restitution that's joint and severable. So they will be each responsible for their proportion. There'll be no weapons while on probation. And the general standard conditions of
I didn't get any
probation.
restitution.
That's,
Your offer was no restitution that you made last week per email.
okay, then we'll suspend the restitution.
It was like, how much? 200?
It's well, confidential, there's about 7 cars got hit all of which have been either repaired at this point.
Right.
Um,
Okay.
So
Okay. Is that your position too, Mr. Lewis?
Yes, Judge.
And what about you, Ms. Hemingway?
Yes, Your Honor.
Okay. Okay.
I'm fine. And that would be it.
Okay. And all three of these are under first offender, right, in Alfred? All
Yes,
right.
Your
Yes.
Honor.
Ms. Hemingway, anything you want to add?
We're just asking that you accept the negotiated plea. We're also asking that Ms. Andrews' records be sealed upon her entering this plea. She has had difficulties getting a job. She does have an interview today, but with these charges popping up on her history is affecting her being able to get a job. She has a 3-year-old and a 7-month-old that she has to support, and it's difficult for her with these on her record. In addition to that, if we can, I guess, hold off on the probation fees, if we can wait until a later date for her to start paying them until she
So,
is able to get on her feet
You
and
mean
get
to
a
waive a
job.
few months?
Right,
Okay.
right. If we can do that, then she may be able to start paying it later, but I don't think she can afford it right now.
Okay. What about you, Mr. Lewis?
I feel the exact same way, Judge. My client has been on an ankle monitor, and the job that he had that he was accustomed to, and Mr. ADA and I have already spoken about this. He's not been able to do it. He's been confined at home, and he does need to get back to work. We were in fact thinking that the last case was going to be null process to be reindicted, getting him off the ankle monitor, and he's been eager to get back to work to support his mom and his siblings, all that are dependent on mom's income right now in the residence. So we would absolutely like for the record to be sealed. Judge, one additional thing, we'd also like the court to impose a behavioral incentive date. My client is 22 years of age. He's a high school graduate. He is a person that has, along with his fellow persons charged with his offense, doing this because it is in his best interest. Nobody wants to face 40 plus years or even 35 plus years going to trial. And for a young person, none of these folks have actually even lived this many years. And so the chance of doing that is daunting. Looking at what the state's evidence is, it doesn't clearly show what my client would produce as a defense. And so because it doesn't, he's at risk, given the circumstantial rules, of being found guilty. So that's why he puts it in. He absolutely doesn't want anything that he says today held against him in any future proceedings, should there ever be one. So we'd ask the court to impose a behavioral incentive date far shorter than the 10-year sentence that's there, recognizing the fact that he has been on his ankle monitor since being arrested and released on this case. And then to seal those records at this point in time with this plea.
I'd ask for at a minimum 5 for a behavioral incentive date.
You'd ask for what? I'm sorry.
At a minimum 5 years for a behavioral incentive.
Okay.
If we would do that, Judge, and I would ask you to count the 2 years that he's been sitting on ankle monitor already towards that 5 and leave it 3.
I'm going to object. Sorry, we're taking a plea today, so.
Yeah. So you still have the ankle monitor on, sir? Mr. Lewis, why didn't you file for a motion to remove it? You know I removed from after 12 months.
Because I was induced by my counterpart on the other side because he was null processing the case. We've been trying to get it off. Null process to reindict. And so we absolutely persuaded, bamboozled, although he's a very good person and he's never intentionally deceptive judge. But the original intent was to null process, to reindict. And so we thought the ankle monitor was coming off. And in fact, that's not the case. So he's confined all of this time.
And Ms. Carter, yours is?
Yeah, it was removed.
His is removed?
Yes,
Okay.
Your Honor. And I just do have some things to add here on behalf of,
So it just came out and I caught him.
okay. On behalf of Mr. Wells, we are asking for the probation to terminate. My request was made based on, I did ask Mr. Wells to complete an anger management course. He has completed that. I do have the certificate for that.
That's Xavier Wells, right? I'm sorry.
Yes, for
Okay.
Xavier Wells. I apologize, Your Honor. In addition, I asked him to complete a gun safety course. He's also done that. However, I don't have the certificate because that would have required him to pay, and I think it was like over $200. But he did show me, I have proof that he completed the certain courses in that gun safety, and that included how to use a handgun, operating a handgun, cleaning, storing, and transporting, shooting fundamentals and position. Intro into hand safety guide was also provided, and handgun parts and operations as well as ammunition. He did complete those. I do have proof of that. So that would go with my request to terminate the probation after 5 years, so long as he's not in any trouble.
Again, same as a behavioral incentive date. I'm fine with that.
Okay.
Your Honor,
So, go ahead.
I would request the same thing that Ms. Carter requested. And this is because Ms. Andrews did also complete the same program. She completed an anger management program as well as a gun safety course. But again, she wasn't able to pay for that either. So she has to pay for that
Okay.
in order to get the certificate.
All right. So let me ask you a question. Ms. Andrews, pop quiz. Let's see if you paid attention. When you pull the trigger on a gun, the bullet comes out. Do you have any control over that bullet once it leaves the muzzle of that gun? A little louder.
No, ma'am.
So, but that gun has to hit and stop on something, right?
Yes, it does.
You said, if I shoot a gun right now, once it leaves the barrel, I have no control. It will stop when it hits something. Am I right?
It will stop when it hits something, but it's still gonna go.
Oh, right, exactly. So if I were just to fire it off in here, the chair could stop it or a person could stop it, right?
If it don't go through, it can.
Basically, yes, you could have shot a person. What about you, Mr. sorry, Jadarius Wells? What's that? So bullet leaves the end of a gun. What control do you have of it? Has to hit something, right? Or is there a special bullet that says this bullet's intended, it only hits chairs, this bullet only hits a wall, and this bullet hurts people, right? What about you, Mr. Other Wells? What'd you learn, Xavier?
Well, a bullet don't have any eyes on it, so a bullet can't see what it's gonna hit.
You graduated top of your class, didn't you? All right. I just know some kid, and I say kids, respectfully kids, younger people today, I don't think some of them think through. It may be because your brain's just still developing, but it's super dangerous because that could have been anybody's mother, son, daughter, you know, your potential spouses, future potential spouse. It could have been anybody, you know. All right. So we'll do them all 10 years probation, 5 to serve, and the other 5 will be suspended.
Upon
That's-
behavioral.
So if you mess up though, it's not gonna be suspended. Yeah, we can get the other 5 in place, okay? And what else? What else?
Your Honor, I think with that early behavior incentive date, it is 3 years is the max.
Is it 3 or 5?
It's 3.
It's 3.
3. That was behavior incentive. I did hear you say that. Okay.
I think Ms. Carter kind of threw a monkey wrench in there, was saying, can probation terminate it early? But
Yeah.
if
But
it's,
everybody just asked for 5.
No, I asked for 3.
3. Hey, Mr. Lewis.
Your Honor, I did have one last request to waive any probation fees for a period of time. Mr. Xavier Wells does have 2 children that he is also providing for. So
Are those 2 children?
Yes.
Those same 2 children? Are you paying child support, Mr. Xavier Wells?
At that moment,
Why not?
cause she ain't got me paying child.
Huh?
She ain't got.
Ooh, okay. So let me tell you
I mean,
something.
I'm a dad. I take care of my children.
Okay, but she ain't got you paying child support where you said she's not. So let me tell you something. So anybody in this courtroom get a phone call from Miss Andrews or Mr. Wells and say, we're gonna have babies, y'all got to help pay for them. Seeing no hands, nobody did. So then, Miss Carter, what does that mean? Whose responsibility is it? Mr. Wells and Miss Andrews, right? Because none of us want to pay child support for a kid that's not ours. She doesn't have to ask you, sir. Okay? I don't want to see you on my child support calendar. So before you buy something new, she needs help with the kids. All right?
Yeah.
So I would suggest you go child support yourself. Do the right thing. And that'll impress me.
Yes, ma'am.
Sound good? All right. Anything else from anybody? So,
Yes, repeat your understanding of what your sentence is going to be judged.
so it's going to be 10 years probate, 10 years, 3 years serve on probated sentence. and the rest will be suspended.
Didn't terminated
Unsuccessful,
upon completion?
successful completion of those 3 years.
Yes.
What else you want, Madam Probation? No drugs, no alcohol, no weapons, no replicas of weapons. What else?
That's a gimme.
Yeah, stay away from the West End Mall, 850 Oak Street. What else? Anger management. There's anger management, the gun safety course. What about, well, y'all all got to have contact with one another because somehow everybody's related. All right.
No violent contact, Your Honor.
Okay, yep. No further violent contact. At least for the whole time in probation, you can no longer have a weapon or be around weapons. So if you live with your mom or somebody else and they have a weapon, mom needs to kind of get rid of the gun in the house because you can't even be in a house with a weapon. Or if you're in an Uber, believe it or not, if you're in an Uber and the driver has a gun, which they're not supposed to, you can't be in the car with the Uber driver. Okay? All right. So for Ms. Andrews, we'll accept that under offered plea given freely and voluntarily and no further contact with, I just had 2 victims. Zaboria Brown, Zaboria, and next one is McAllis, Macalous, last name Ester. So no further contact with those folks. That's the 2 alleged victims, or at least that were listed. Okay, Mr. Lewis?
Yes.
All right, anger management, gun safety. Are you either one at Mr. Wells, Xavier, or are y'all working, Mr.?
Yes, I work.
You're working. What about you, Judith? All right, so we'll take your ankle monitor off, okay? And I wish I would have known beforehand because I really only make people wear it a year as long as there's no problem with it. So we'll take your ankle monitor off so his ankle monitor can be removed. And you're looking for a job. How long do y'all need? I could waive probation fees for what? 5 months, 6 months? That help?
Yes.
You, Xavier, need to start paying some child support.
Yeah, man.
It's gonna be part of your probation. Get on child support and pay it.
Yeah, man.
Okay? All right. So we'll waive 6 months and you can start paying after that and give y'all time to save up some money, okay? Because I want to incentivize everybody. All right. Well, freely and voluntarily.
And then that last
Mr.
part,
Lewis,
Judge,
I'm
you're
revoking your
absolutely-
probation, Mr. Lewis.
It's okay. You'll have to revoke me, but I'm going to fight for this young man. I need that record sealed right now so that he can get out there without the stain of a conviction. Yes, absolutely.
Employment.
Yes, Your Honor, that was my request as well.
Yours, everybody joining in with Mr. Lewis. Okay. All right. We can do that.
I'll draft an order and send it.
Okay. Are you going to draft anything, Mr. Lewis?
If I can get a learned counsel there to put all of us on the same order, that we would appreciate it.
I don't think that's how that's gonna work, Mr. Lewis.
Oh
You'll need
my
to draft
God. I'll draft
Oh my
my own.
God. Yeah, you'll have to draft your own order.
I'll
All right.
draft
Y'all
it.
just shoot me the order. Y'all can copy, Ms. Woods. Did you get my text, Mr. Lewis? So I sent you what we're in the hallway talking about?
Yes.
All right. All right. Thank y'all. I'm going to
Thank
step
you,
off
Honor.
okay. I'll step off the bench for a second so that we can make sure everybody gets out here with no issues. And then we're going to go back to the other ones next.
Think so.
Well, oh, how much of a charge do we have? I think she's letting them eat for 30 minutes. Okay.
And then.
Did we on this?
But I mean, I'm still drafting it, so I'm almost done, we'll get it like. At least completed today.
I'll be back in a second. So.
Okay.
I don't know.
All right. I'll be back in a few minutes.
All right.
And this one?
In the hall, because I don't have a key card for this.
That's what I've always done.
I used it before.
Oh,
Takes you an hour to do a plea frank.
Oh, that's great.
I'm gonna put it right here on my computer. Just in case.
My only copy.
Well,
saying, but
I'm a black
if I
woman.
come back.
All right. Okay. You wanna do it? I don't know.
No, well, so,
Because it takes you an hour to do a plea, frankly, we don't have an hour.
No, I mean, hey, sorry, this is a multi-plea.
no, so what we're gonna have to do, let me see,
Unless Judge, you wanna do it after you finish doing everything else. and
so y'all
we'll
got a
take
couple
break.
choices. One, I've gotta charge the civil jury for Judge Wall.
Hmm.
And it's just this one last plate, right?
Well, two. He's got another one in
Oh,
custody.
you got two. Well, he has two cases, right?
Well, not when I have one in custody.
Oh, one in custody. Here's the thing, though. So we can either reset it and I can take them, or we can continue it till next week. So since,
I gotta be in Cobb. If you have to go do something else, which is fine.
no, I mean, you can just, you gotta be in Cobb today?
Yeah.
And you know what? I mean, I'm okay with next week as long as, and I'm just gonna do this in abundance of caution because I got subpoenas out and all that other fun stuff. You all get on the record and you waive your right to a jury trial that this will be a plea. Okay.
What day next
What
week?
did you say?
All right, I'm pulling up my
All next week?
calendar, to see what I could,
Oh.
let's see. Boom, 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 boom. It could be,
Hold on, I'm gonna tell you.
yeah, it could, yeah, it could be Wednesday.
What day is that?
It's the 8th. What, especially second. Or it could be Monday. The 6th or the 8th. Okay.
Six is better for me. I'm in right there all day on the 8th.
Ooh,
What about the other attorneys?
Ms. Hemingway,
I'm so sorry.
the 6th, Monday?
Make sure the client can.
That's fine.
I'm on
Can
the
you check
trial
with everybody?
calendar for May the 6th. I haven't been called in, so
You're supposed to be where?
I said I'm on a trial calendar. I haven't been called in.
For who?
May the 6th, Judge Ingram. She normally does a short list. I haven't seen my name on that list, so.
Okay, okay.
Are they gonna be in court by themselves?
Whoa, stand by.
Hey, don't leave yet.
Hold on, stand by. Hey, yo.
Hold on. Give me
What, Monday works for your
the-
client?
Does that work for all?
Monday works for
parties?
my guy, yeah.
Yeah.
And pretty sure unless something,
Unless I get called in.
right, so,
Then-
but if we do something, I could talk to Ingram, we could like just, because it shouldn't, I mean, it'll take a few minutes, but I could ask Ingram if we could do it. You know, we gotta do this, okay?
That's fine.
All right, so, and then anything else? And then we'll do your other one on Monday, is that good?
Yeah, he's in custody, so.
Okay, he's good. Anything, that'll be it for the calendar? Yes, Ms. Carter.
I have an issue because Judge Schwal, I had a meeting with him this afternoon about a protective order, an order and a non-negotiated plea.
Uh-huh,
And so he said he would grant the protective order. He wanted me to draft an order because the DFACS filed a motion to quash and.
oh, I got you.
And then he also gave me he agreed to my negotiated plea our non-negotiated plea for one of my clients. So I don't know what the court wants me to do. Should I send you the protective?
Sure, you can
order?
send it to me.
I'll send you the order for
Yeah.
motion to quash and then
Right,
my client will come back on Monday.
yeah, is
the
that,
plan?
yeah,
No, he's
Okay.
be on Monday.
is that okay? Your client's not incarcerated, right?
No, she's not. But
Okay.
Monday.
Okay. All right, sounds good. All right, we'll see everybody Monday. Everybody, please keep.
We'll be inside at work.
5
Yeah.
I'll see you on Monday.
All right, thanks.
If you wanna come at 10 or 11, what time you?
What time do y'all want? 10, 11?
9 is fine with me. What 10?
What?
10?
10 a.m. is.
10 a.m.?
You're the better, right?
Earlier the better, yes.
10.
Yeah.
Okay.
Anyway,
10
what do you
a.m.
want
is
to talk?
upstairs. It's sometime about I think September, October was the last time. I think this happened around September, October timeframe. So he had not seen the child. He didn't think that dropping her a gift off for Valentine's was in violation, and the bond order sometime about I think September, October was the last time. I think this happened around September, October timeframe. So he had not seen the child. He didn't think that dropping her a gift off for Valentine's was in violation. And the bond order just said for him to stay away from her family. And he, it was a bad judgment is what it was. He has not communicated with her or the child for months and months and months. It wasn't his intention to harass. And so we're just asking that his bond that he's on be reinstated or that a reasonable bond be issued on his
Right.
behalf. And I ask that if you may consent to that bond. And I know that you sent something over, you had some communication with my assistant, Mr. Fair, earlier on today. So that is our position. And we're going to ask the court to at least give him an opportunity to post the bond and be released.
Well, I appreciate you being here and I appreciate what you're saying, Ms. Waters, but I wasn't kidding before when I said request denied. I did review your request and the documentation, and he was ordered to have no contact, as you indicated, as a condition of the bond with the mother of the child and the child, and also the TPO order was granted. And I believe in your motion, you said he went one time to the school on February 14th, but according to the warrant, he actually went two times, February 14th and February 28th. And so we're concerned about intimidation as well as the safety of the child and the victim in the case. And I did also loop in Deputy District Attorney Asia Beja, who is in charge of our domestic violence unit, where the case will be headed, because that's where the original aggravated assault case is. And she also said that she would not be consenting, at least at this time, to anything, because she's also concerned about safety and intimidation. So the state is unfortunately not consenting to your motion. We're opposed to it. I would encourage you, and I also encourage Mo to reach out to Deputy DA Asia Beza if you'd like to discuss it further with her. It may be that she may agree to it in the future, but she's not agreeable to it today.
Okay, so in my motion, I did cite that he went to the book fair and that he went and dropped off a gift. He did not see the child on the 14th. He dropped a Valentine's gift off at the school and left. So he didn't even see the child on the 14th. On the 28th, he did. So, but I'm concerned with how you're phrasing that. Why do you think that the child is at risk? And why do you believe that he is harassing and intimidating the child by dropping off a Valentine's gift and the book fair? I understand. I mean, he had bad judgment in that regard, but it wasn't in an intimidating fashion, nor did he do anything to make anybody uncomfortable for that matter. And again, you have the right to decline, consenting to the bond, and I can appreciate that. But the harassment and the intimidation and the concern that he is going to do something to the mother or this child, I don't know that this situation rises to that level.
Well, I would encourage you to speak with Ms. Beza, and I don't mean to cut you off, but the case is not going to be mine to prosecute. It'll be Ms. Beza's. And I'm looking at her email now, which she also included Morris Fair on it. And she said the state, and she said at this time, the state is concerned with the victim's safety and the fact that the defendant violated the TPO twice. Therefore, the state does not consent to bond at this time. So, the original charge, I believe, was aggravated assault, and then that was followed up with 2 violations of the TPO and bond order. It's checking all the boxes for denial of bond. At this point, from my cursory, well, more than a cursory review, but I would talk to Ms. Beza about it since her unit would be prosecuting the case.
So just email her, Ms. Waters, and you may get a little more there.
Okay,
All right. And I apologize, I'm just not able to work with you on it this evening.
and Judge, is it your position that you're not able to make a ruling on whether or not he should get a bond in lieu of the state opposition?
But here's the thing, since the motion's not before me, that's why I kind of told you to speak with Mr. Malkin and maybe he could look over it. Because I haven't even seen the motion, but they'll also bring you in front of one of us for that motion. And it obviously, I mean, it could be me. In that event, I will, but I've known that Ms. Basil, she's pretty reasonable. So I think maybe reaching out to her would be a fantastic start. And then once you guys they'll come to a consent, I'll be glad to take care of it.
All right, I appreciate it, Judge.
Yes, ma'am. Have a
Thank
good
you,
day.
Brad.
All right. Thank you.
All
Ms.
right, you have a
Wallace.
good evening as well. Thank
All right,
you.
we have Ms. Guest on here. Let's start with Nortisha Woods. And gentlemen, since it's just one lady here, gentlemen, when I call your name, take yourself off. Excuse me, don't say, wave at me so I know who you are. Don't put your head down. Don't walk out. Don't do anything. Okay, stay where you're at. Wave your hand immediately. Don't sit there and think about, she mispronounced my name. I just might. I've been told I have an accent, but I don't hear it. So if I mispronounce it, I apologize in advance, and we'll get through this as quickly as we can. Nortisha Woods, number 17. I got 199 days without indictment. 23 CP 221288. Aggravated battery. Right now, as of January the 19th, there is a $3,000 good bond. Rah. Well,
Judge, I don't think anyone from pretrial, I saw Miss Mann come
yeah, I
on.
did too, but she left.
She left. I'm not sure if there's anyone else. Let me see if I can reach out to someone over there to see.
Yeah, let's see, where'd she go? Maybe CME scared her off. Let's see. One second, let us find somebody here. I'm texting her too, so.
You're texting Miss Mann?
I'm texting Miss Mann, yeah.
Okay. All right. Did you want me to reach out to, okay, somebody's waving in 5 South Booth 3.
Bogle, can you unmute that? That's Bogle.
Bogle, okay, hold on, give me a minute, let me unmute it, hold on.
What do you think, LT? He looks pretty good sitting there, don't he?
He does.
She says, I tried, but I received a forbidden code. Now Officer Jackson has well. I'm in the middle of calling RIT. I don't know what a forbidden code is.
You're unmuted, Bogle.
Okay, 6 South booth number 3, can someone turn it on for Frederick Smith?
Yeah,
Frederick Smith is not needed, he's not needed.
Is
Frederick
anybody
Smith,
else I just pulled him off a visit, so is there anybody else that's not needed?
no, that was it, Frederick Smith was not needed, that's the one that's gonna be, he's gonna be reset.
All right, I'm gonna go get you other people.
All right, thanks, Bogle. Taking a picture of it and sending it to Miss Mann. Let's see. We spoke too soon. All right, hold on, let's see. I don't know what to tell her to do. Let's see. All right, let's see. Mr. Roy, I'm gonna I'll share this man's info with you. Maybe you can call her and see.
I have her info. You want me to reach out to her?
Oh, okay.
Yeah, when you were communicating where I didn't want, both of us, so you want me to just reach out to her to see?
Yeah, maybe if she's got like another device she can sign in from.
So it was Miss Mann whose device was saying a code?
Yeah, and she also said that it was Miss Jackson's too.
I'm not sure. Okay, let me reach out to her.
Okay. I just told her to try from her phone, so she said, and I sent her the picture of from the screen, the meeting number, but I mean she was here, so I don't know what happened.
I'm not sure, Judge. I'm on the phone with her now. I'll see if I can assist.
Mr. Powers, I think you only got one case tonight, right?
That's right, Your Honor. It's one defendant. I think there are three separate cases, but yes.
That is, which defendant is that?
It is Michael Nashawn Jackson, positions 3, 4, and 5, I believe.
Oh, all right, we'll try to take that after we do these other two so that they can get out. Let's see, there it is. That way you don't have to sit here all night.
Appreciate it, Judge. Thank you.
And it's storming here. I'm trying to open Odyssey, see if I can at least see the old pretrial report, but it's going slow.
Who are you looking for, Your Honor? Maybe I can find it on SharePoint.
Well, it's Nortisha Woods, if you can figure out her. If we don't have Miss Mann or anyone here. You two gentlemen that are sitting there with the doors open behind you, pull them closed. You're not going to be able to hear.
Let's see, 13 cycles. Let's see, an arrest August 19th of 23 for failure to appear. Let's see, there was an aggravated assault arrest, August 19th of 23. Attempted burglary on September 12th of 2018. Interference with government property, that was declined. Disorderly conduct transferred to state court from 2016. Criminal trespass from 2015. And these are all just arrests. Let's see. Possession of cocaine in 2014. Criminal trespass 2013. And there was another criminal trespass and theft of lost or mislaid property that was dismissed from 2012. Possession of cocaine from 2012. Criminal trespass 2009. There was a disorderly conduct conviction from 2006. Criminal trespass 2006. I think that was the disorderly conduct. Yeah, that was changed from criminal trespass. Another failure to appear in 2006 for a DV simple battery. And there was a simple battery conviction from 2006. So I just see a couple of misdemeanor convictions. Don't see any felony dispositions.
All right, Mr. Guest, you agree? Go ahead.
Yeah, Sharon, I just would like to bring to the court's attention, and I don't know if that was Mr. Malkin spoke to that, but the 2023 aggravated assault that Ms. Woods had in court, it was aggravated assault and aggravated battery, I believe, aggravated assault, simple battery. That case was dismissed. I represented her in that, and it was dismissed late last year. But Ms. Woods is 42 years old. She actually just turned 42 back in January while in custody at City of Atlanta Jail. She is 23 years old and she has been in the Atlanta area for the last 23 years. She does have a mom that is not locally, but who we have been in contact with. Ms. Woods finished up to the 9th grade. And I just would like to make the court aware that currently the $3,000 bond is not a bond that Ms. Woods can financially make. She does have a valid address. It is unfortunately in Fulton County. So we would ask that no stay away from Fulton County is implemented in any bond order. We have filed a change of address to reflect her updated address. I actually have been in contact with the Women on the Rise organization, and they are in the position to allow Ms. Woods to enter into their program. However, they are not financially able to make bonds at this time. It's my understanding that they only are able to make bonds during holidays and Mother's Day. So Ms. Woods is not able to make the bond. The only way that she can actually be released to that program is if the bond is perhaps lowered. I don't know with this being a prohibited bail restricted charge if it's possible, but we would be asking that the court considers a bond, if not a UJR at the highest level of supervision released to this program, at least a $1,000 good bond, seeing as though she's been in custody for almost 200 days without indictment. And I would ask whether or not they've had opportunity to contact the alleged victim.
I don't see an indication about that. We would consent to the $1,000 bond. Is this something that the bail project would assist with, Ms. Guest?
I know that we've reached out to the bail project, and currently right now, due to the issues of Fulton County, they're not posting bond. And for whatever reasons, but I'm not really sure. They denied our original request from Ms. Woods. So we are in the process of resubmitting her information to see whether or not they would reconsider her for that project. But I believe that the best alternative for Ms. Woods is going to be the Women on the Rise program.
Sounds good. So we'll consent to the $1,000 with the Women on the Rise. No
All right.
contact with the victim.
All right, let's see. No drugs, no alcohol, no weapons, no replicas of weapons. Stay away from 888 Ralph David Abernathy Boulevard. No drugs without prescription. Let's see. If available, you have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment. You have to supply the name of your employer, proof of employment schedule, and the exact location that you are working. Enroll in Women on the Rise and participate in that program. So it'll be a $1,000 good bond. Best of luck to you, ma'am. Thank you, Milton.
Just quick question on the enrolling the Women on the Rise. That's something that she's gonna do from in custody.
Does she go there in custody? They come get her, Miss Guest.
They'll actually come and get her once we successfully enroll her in the program. I can prepare that transport order.
All right, sounds good. Thank you. Thank you, Milton. Jeffrey Norton. There we go. Position 8, 23 CP 223-899. Jeffrey Albert Norton Jr., 92 days without indictment. Right now, there's a $5,000 good bond as of December the 6th with burglary in the second degree. And you're off the hook, Mr. Malkin. Hey, Miss Bridget Jackson. Wow. Mr. Norton, I don't need you to say anything. Go ahead, Miss Jackson.
I didn't realize it was off on me.
Ms. Jackson. Miss Jackson. Go on, Miss Jackson. I have Miss Jackson's phone number. Let's see.
I have the GCIC, Your Honor, if you like.
All right, let's see. Okay, go ahead.
All right. And I can't go as fast as Bostic, but let's see. All right. So there are 13 cycles, and the last one is burglary second degree, which I guess is this case, from December 5th of 23. Before that, there was probation violation in 23, and there was a revocation, it looks like, in 23. Another probation violation arrest in 23. It's a different cycle. And another probation violation arrest in 23. Same arrest date, but different cycles. So not sure about that. Interference with emergency medical professional by use of threats or violence, obstruction, and criminal trespass arrest from 22. Cruelty to children, third degree sentence from 2023, it looks like. And that was a misdemeanor, probation. And then there was a family violence battery and cruelty to children, third degree. Let's see, is that the same? That's the same cycle. And there was a theft by receiving arrest in 2019. Prior to that, another probation violation, and that says conviction felony. That was in 2019. Looks like that was for a theft by receiving stolen property, and it's got a 14 SC number. So, and went to prison on that one. Sale of methamphetamine, 5 years in prison in 2016 from Coweta County. And it says 5 years probation, so maybe it was a 10 to do 5. Simple assault arrest in 2016.
Your Honor, we would like to object until pretrial is ready. I understand
But
it's a
he's reading that. She hadn't.
little bit late for this, but I apologize.
All right. Well, he's done. So go ahead, Mr. Rogowski.
Yes, Your Honor. Well, Mr. Norton is 32 years of age. He's currently residentially challenged. He's been living in the Atlanta area for his entire life. He made it to the 10th grade in school. Your Honor, he's currently being held on a $5,000 bond. There is no way that Mr. Norton, with his indigent status, is able to make that bond. He has gone over 90 days with indictment, and I understand that that doesn't mean anything, considering he already has a bond, doesn't mean anything more than the state has failed to indict that case in that time without reason. But we would be asking for a reasonable bond reduction. There is really no amount of money that Mr. Norton could make, and we would be asking for this bond to be lowered to $2,000. So that way the bail project, if they are able to continue paying bonds within the next foreseeable future, would be able to pay his bond for him. But perhaps, I know with the bonding fees, they have been very reluctant prior to this whole, system outage to pay bonds that were close to that 5,000 mark. So we believe that Mr. Norton would more appropriately have a $2,000 or $3,000 bond. So that way he would be able to get that paid through them. So that is what we are asking for, Your Honor. Thank you.
All right, go ahead, Mr. Malkin.
We'd ask for a $4,000 bond, please.
All right. Miss Robinson, isn't 4 North the one that's messed up?
4 North Booth 3.
Well, 4 North Booth 4. 4 North Booth 4. Can you hear me? Yeah, I think he's having problems hearing.
Okay, I'll try to see if I can open up another booth on 4
Well,
North.
Booth 1 is open for 4.
Yeah, if you want to get into 4 North Booth 1, it's open.
All right. 4 North Booth 2. Raise your hand. You, sir, can you do me a favor and get the gentleman in 4 North Booth 4? Tell him to go to Booth 1. Thank you, sir. All right. All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Must provide an address, but upon release, stay away from Global Impact Academy. That's at 155 Shaw Drive in Fairburn, Georgia. $4,000 good bond. Best of luck to you, sir. Thank you, Alpharetta. All right, Michael Jackson. Well, that may be the other guy, right? Michael Jackson. There we go. Gentlemen, stick your hand up when I call you. Don't hesitate. Thank you, Mr. Jackson. All right, so now here's a day's one on here, but I think we got it fixed. 23 CP 223892, 91 days without an indictment. There is no bond on possession of a firearm or a knife during the commission of a felony, receipt, possession, transport of a firearm by a convicted felony, felony first offender, possession of tools for a crime, failure to obey stop sign, aggravated assault against a law enforcement officer when engaged on official duty, unlawful for a person employed by associated with criminal street gang to conduct or participate in criminal street gang activity, unlawful for a person to commit the offense with the intent to earn a membership, maintain status, or increase status. Now there is 23 CP 223925, 91 days without indictment. We got 3 counts of entering auto with intent to commit a felony. And then 1 count of theft, 2 counts of theft by taking. Then we have unlawful for a person to commit the offense with intent to obtain, earn membership, maintain, increase status. An unlawful for a person to acquire, maintain through criminal gang activity, proceeds derived therefrom. And then we got 23 CP 224305, 91 days without indictment, no bond as of 12/21. Burglary, smash and grab, unlawful for a person to commit the offense with intent to obtain, earn membership, maintain, or increase status. And then unlawful for a person employed by, associated with criminal street gang to participate in criminal street gang activity. 5 North, have a seat, booth 3. And then unlawful for a person to acquire, maintain through criminal gang activity, proceeds derived therefrom. And that is no bond. So they're all no bond status. Wow.
He has 10 cycles. Can everyone hear me?
Yes, ma'am.
Great. All right. The last arrest was March the 19th, 2023. That was in Fulton County for a probation violation. The underlying charge was a felony. He does appear to be on first offender probation in Fulton County. That case number is 19 SC 165-729 for criminal street gang activity. That disposition date was September the 3rd, 2019, and the term is for 7 years. He does have a prior felony conviction. It was in 2022 out of Cobb County, a criminal attempt to commit a felony. Nothing in addition, Your Honor.
All right, go ahead. Who is this? Ms. Guest, go ahead.
Yes, Your Honor. As you stated, Mr. Jackson has been in custody for 91 days, and the state has failed to indict his cases. So today he actually is going to be legally entitled to have a bond set on all 3 of his cases. Mr. Jackson is 22 years old and does have a valid address where he would reside. He would reside there with his mother, who I have been in contact with and had the opportunity to speak to. She would have been here today, understanding that family are not allowed on the Zoom, but she is in support of assisting Mr. Jackson in obtaining a bond. Prior to being arrested, Mr. Jackson worked as a forklift driver and does believe that upon his release, knowing that he has a forklift driver's license, he can obtain a gainful employment. He also had completed the 11th grade. He has a 1-year-old son who he also is financially responsible for, who actually had a birthday while Mr. Jackson was in custody. Mr. Jackson is a important part of his family. He does financially assist his family, and his mom has been having some hardship, seeing as though that Mr. Jackson has been in custody and unable to financially assist his family monetarily, Your Honor. So today we would be asking that you place a bond on these 3 cases. We're asking for a bond in all 3 of Mr. Jackson's cases, not to exceed $100,000, Your Honor.
All right, go ahead, Mr. Powers.
Thank you, Judge. The state's concerned about Mr. Jackson currently, having 3 separate cases here with, I believe, just 1 arrest date for all 3. The fact that he was on first offender probation and a felony sentence. And I believe that his first offender sentence was also for criminal street gang activity. We would ask for the criminal street gang charges to be $40,000 each. I believe there's a total of 7 of them across the 3 cases, and we would leave it into the court's discretion for his other felony charges.
All right, he's going to live in Fulton County, Ms. Guest.
Yes, Your Honor, that address that he has is in Atlanta, Georgia, Fulton County.
Okay, case ending in 3892, and allegedly, what is the name of the gang he is a member of?
Judge, it is, I had it right here a second ago. It is Down for Whatever, DFW.
All right. No drugs, no alcohol, no weapons, no replicas of weapons, no social media, no contact with any gangs, any affiliates of gangs, anybody who thinks they want to be a gang member. That also includes anyone that's a member or an affiliate of Down for Whatever. So I've got 20,000. 20,000. Or failure to obey a stop sign. I think, let's see, 1, 2, 3, 4. We'll make that a UJR for failure to obey a stop sign. Count 5 is aggravated assault against a law enforcement officer when engaged in their official duty, 50,000. And then, make sure I got that right. Miscount, let's see. 7. Wait, 1, 2. Excuse me. I hate when they're different. Sorry, on seven and 8. Let's see. 7, 8, 6. All right. Position tools for a crime is number 4. That's a UJR. UJR on the, and I'm going by the former bond order, Ms. Robinson. Failure to obey stop sign, UJR, 50,000 on the aggravated assault against law enforcement officer, 40,000 on bond, 40,000 on gang, 40,000 on gang. That's 20, UJR jail, 50,000, 40,000, and 40,000. Let's see, no further contact with Kareemah, Kareemah, tanks. stay away from 1056 Welch Street. All right, this one ending in 3925. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. And look like this, all the gang charges were dismissed. Wait, no, 567. Oh, there you go. No, there's some gang charges. All right. I want to make sure on the bond order that they all equal up. So let's see. Entering auto with intent to commit a theft or a felony, 10. Entering auto with intent to commit a theft or a felony, 10. Theft by taking felony, 10. 5 is a gang charge, that's 40. 6 is a gang charge, that's 40. 7 is a gang charge, that's 40. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. No social media. Stay away from 360 Marietta Street Northwest. No further contact with Brianna, Breyanna Edwards. No further contact with any gang members, any gang affiliates, and anyone who thinks they want to be in gang or a member of DFW, down for whatever. Next one is ending in 4305. No drugs unless prescribed, no alcohol, no weapons, no and all those you're going to have an ankle monitor. Sorry about that. Losing my train of thought. All those you're going to have an ankle monitor paid for by the county if there's an ankle monitor available with a 24-hour curfew. Court, lawyer, medical only. Court, lawyer, medical only. This next one I'll do, stay away from 6300 Powers Ferry Road Northwest in Sandy Springs. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no social media, no further contact with Lamont Brown or Aisha, Aisha Turner, Turner. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical only. So I'll do 10 on the smash and grab, 40, 40, and 40.
And Your Honor, I just wanted to go back to the case ending in 925. I believe that you said that there were 3 gang charges. I just wanted to confirm. I thought it was only 2 on the.
No, I'm sorry. There's 2 gang charges and 1 ag assault.
Yes, Your Honor. Okay.
I'm sorry if I misspoke, Ms. Guest.
Judge, can you go over that amount? Because I don't think it was that he had another count of theft by taking.
Wait, on the last one?
Yeah.
Okay. Sorry, they kind of,
Please.
wait, on which one? Because this is burglary, smash and grab, and 3 gang charges. So which one?
On position ending in 925, I have he has 2 counts of theft by taking.
And the other one's the other one's theft by taking, 10,000 on that theft by taking.
So it's 10 on all the entering autos, 10 on all the theft by takings, and 40 on all 2 charges of the gang charges. Is that
Yes,
correct?
ma'am.
Thank
Yes,
you.
ma'am. Thank you. Best of luck to you, sir. You could leave the booth.
And that concludes my business with the court, Your Honor. May I be
Yes,
excused?
ma'am, Miss Gass. You too, Mr. Powers. Y'all have a good weekend.
Judge. Thank you.
All right, I got John London. All right. This is position 9, 23 CP 223908, 92 days without indictment. And I didn't set this, there's a $5,000 good bond on aggravated stalking and burglary in the 1st degree as of 1/5/2024.
He has 3 cycles. The last arrest was November the 1st, 2021 out of Gwinnett County for a DUI. There was no disposition for that arrest. He only has misdemeanor sentences. He received a first offender treatment in 2019 for simple battery, family violence. That case was sealed January the 19th, 2022. And he received a nolo contendere sentence in 1988 out of Gwinnett County for deposit account fraud. Nothing in addition.
All right, go ahead, Mr. Rogowski, and I see that it appears someone named Pamela London is on here. I'm not sure if that's the victim or someone else.
Yes, Your Honor.
Victim and the wife as well. And I saw Andrew London. He's the son.
Okay, let's see. Do you want to go ahead, Mr. Rogowski? Or do you want me to hear from Ms. Pamela London and Andrew London first?
They can start, and I'll follow up
All right.
after that.
Ms. Pamela London, if you do me a favor, start your video and take yourself off mute. All right, if you can raise your right hand for me, do you swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
I do.
All right, if you don't mind stating, spell your name, Miss London, for the court reporter.
Pamela London, Pamela, London, London.
All right, Ms. London, really all I'm concerned with is if what you're concerned about as far as his bond conditions and him getting out. Like, are you in fear for your safety, etc.?
Somewhat fear of safety, but more fear of his safety and the community. He definitely needs some help in with alcohol abuse and substance abuse. He needs some mental treatment. He needs direction, and I'm concerned that if he's on bond, that he'll just go and get into trouble because he doesn't have any resources at this point to have a place to live and stay and be safe.
So you took out a TPO against him that's in place. He violated that TPO?
Yes, ma'am.
Okay, obviously he did. How many times has he violated that TPO?
Just that one time. It had just been ordered, and he was so quite intoxicated at the time. That was part of the issue of all his behavioral problems.
Did you show up in front of me, Miss London?
No, the other judge. Yeah, I
Okay.
did show up in front of him. Yes.
Okay, all right. All right. And does Andrew London, does he have anything to say, or is he just here to support you?
I think he could say something. Yes.
Okay, Mr. London, if you will take your turn on your camera, take yourself off mute, please. If you could take yourself off mute, Mr. London. That little microphone.
All right.
And your camera on at the same time.
Can you hear me, Your Honor?
Yes, sir. If you raise your right hand, do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, Your Honor.
All right. If you state and spell your name for the court reporter.
Andrew London, Andrew London.
All right, go ahead. Same thing, your fear for your safety, your mom's safety, or what have you, or in your opinion about him getting out.
Your Honor, I don't fear for my safety in regards to my father. I love and care about him. He, for the majority of his life, he's been a good father. In 2018, he had a psychotic break, which led to 7 or 8 years of issues ongoing. I don't have a place for him to go. If he's released on bond, he'll essentially be in the streets or whatever organization will provide him with housing. I do wish that if there's any kind of help that he can receive as far as substance abuse, which will help put him on the right track to get off of those things, or at least counseling, or mental therapy counseling. He's not a proponent of doing any kind of drugs pushed by pharmaceuticals, but if those things could be included in a bond order, that would substantially help him get on the right track. The idea is to get him back to where he can be a suitable partner for my mother and help him get there the right way. I know right now he has pending charges with the county, but that's all I have to say, Your Honor.
Okay, thank you so much, Mr. London. Go ahead, Mr. Rogalski.
Yes, Your Honor. Mr. London is 68 years of age. He is currently residentially challenged, as from what you had previously heard from his family members. I had filed a request with my social worker on the 4th of January to explore our options with Mr. London. However, at the moment, we do not have any sort of program lined up for him, as well as I had a phone call briefly earlier today because Miss Pamela London had reached out to me. So her and I had spoken about what I could tell her that was not privileged regarding the situation with that, but was not able to, of course, release any of the information such as client, conversation that was privileged. So with that being said, it leaves us at the moment without a program and without any ability to be able to place him. And that is where I will leave that, as that is the line of where privilege would end. Your Honor, he does, of course, have a lot of family here. He's been living in the Atlanta area for his entire life. He has a Master's of Divinity from Regents University. He is a retired minister as well, so he does have incredibly strong community ties. Your Honor, he had also served 3 years in the Vietnam War as an Army veteran, so he is a service member. He has 4 grown sons, 3 of which are in Atlanta. Your Honor, from the conversation earlier with Ms. Pamela London, and I urge her to correct me if I'm wrong on this, but she had stated to me that he has not reached out to her in the 3 months where he has been incarcerated. So he is following with that TPO as far as to my knowledge, which is good at the moment. And Your Honor, a $5,000 bond is not something that is attainable for Mr. London. So we would be asking for that bond to be reduced down to 2,000.
All right, go ahead, Mr. Malkin.
Thank you, Your Honor. I spoke with Ms. London earlier this afternoon, and I did give her Mr. Rogalski's contact information, which she asked for. We are concerned with the fact that Mr. London does not have a place to go. Should the bond be lowered to a lower amount that he's asking for, which may put himself at risk more than Ms. London, even as she has indicated. And there's additional information where, he put himself at risk, took himself down to Florida, and Andrew London had to go and retrieve him from the beach where he was staying in his car, is my understanding. We would not necessarily object to, say, a $4,000 bond, but we do need him to have some conditions, a place to go. So that is of great concern to the state that Mr. London doesn't have a place to reside. And without having a place to reside and having no access to money, he essentially would be on the street and would either commit more crimes or resort to possibly going back into the residence or trying to obtain money, which is what happened here, and putting himself or other people in harm's way. I understand from Ms. London that she does want the no contact provision regarding herself to stay in place, but she informed me that she believes that Andrew London does not need to have that no contact order in place for himself, and that he has been in contact with Mr. London by phone while in the jail. So we can confirm that with Mr. Andrew London if he would like that condition removed as to himself. But there's also no drugs are allowed, no weapons, no alcohol. Ms. London will like to add no smoking to that. She also said he's in desperate need of counseling, life counseling, AA, NA, and so that's when I said that his attorney would really be the one to talk to about getting him into some kind of program that could provide some counseling along those lines. And so that's kind of where we are. And so I would hope that the PD's office might be able to, their social worker might be able to find some sort of residential program for him that provides counseling in the near future.
Miss London, if you take yourself off mute, does he have benefits through the VA?
Yes, he does. I don't think he's ever pursued them, but he is a veteran and was discharged correctly.
Okay.
So,
Sir, give me a thumbs up or a thumbs down. Do you have benefits through the VA? Thumbs up or thumbs down? Mr. London? You don't. Did you not apply for them? Yeah, okay, anyway. Because I was going to say, because you can get into the VA and the VA can get you into several places. You can get help through the VA. All right, let's see. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no smoking, anything. You obviously got some sort of issue with that. Stay away from 500 Devonshire Farms in Milton, Georgia. No further contact with Pamela London. I don't care if you contact Mr. Andrew London, but Mr. Andrew London tells you to stop calling him, stop calling him. Let's see. You're going to have an ankle monitor paid for by the county, if available, with a 24-hour curfew, court, lawyer, medical, and being in a treatment program. Previously, somebody put you couldn't come within 5 miles of her house.
I saw that.
So How about we do that at 5 miles from her house, work, or her church? Let's see. Must supply address where you're going to be living upon release. And sir, I didn't do your TPO, but if I would have heard your TPO, I make it clear. No contact is no contact. No carrier pigeon, no paper plane with a little note written inside. Don't even make one of them notes that look like a football you used to kick through to your neighbor while you were in high school. No way. You don't tell Andrew to tell her anything. You don't tell anybody to tell her anything. Absolutely no contact with her. So I'll be 3,500 and 500. Best of luck to you, sir. You can leave the booth. Thank you, Mr. London and Miss London. Y'all stay healthy and safe. Have a good week. You can go ahead and leave the meeting. Thinorius Crumbly. All right, number 6, 23 CP 220253, 233 days without indictment. Right now, he's got a $50,000 good bond on. Okay, so on the bond order, it says ag assault, possession of a firearm during the commission of a felony. Mr. Dobbs, did one of them get dismissed?
Well, Judge, you said $50,000. His last night court session, his bond was set at $20,000 total.
20,000. I was about to say 15 and 5, but is the possession of a firearm still there?
Judge, I believe it is still there. But yes, I believe it was added at the prelim. Yes.
All right, go ahead.
He does not have any prior arrest on file, Your Honor. Nothing in addition.
Go ahead, Mr. Dobbs.
Thank you, Judge. If released, Mr. Crumbley would reside with his father, Norris Crumbley, at 3681 Albia Drive, which is in Decatur, Georgia. Mr. Crumbley is a native of the Atlanta area, specifically DeKalb County. He has never lived anywhere else. So as you heard from pretrial, this is Mr. Crumbley's first time ever being arrested. That is on file. In about just a few months, he will have been in jail as a legally innocent person for 1 year. The state has had the opportunity to indict this case prior to Mr. Crumbley being entitled to a bond. They didn't. Mr. Crumbley was given a few bonds he could not make. Months apart. They didn't indict it in between any of those. I suspect the state will talk about the facts of the case possibly, but if it's so serious, they've had every opportunity to indict it. They're the only entity that can move it forward, but they haven't, because Mr. Crumbley has strong ties to this area, because he has no criminal history, because in just a few months he will have been in jail for a year. I'm going to ask for a reduction from $20,000 to $10,000. No, nothing to exceed 10,000 aggregate. Thank you, Judge.
All right, go ahead, Mr. Malkin.
He shot the victim in this case, so we would ask that the bond remain the same.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay out of Fulton County unless you're here for court or to see your lawyer. That's the only 2 reasons you come into Fulton County, sir. Don't get gas, don't get snacks, don't stop at Chick-fil-A. Put it in your car if you plan on coming to Fulton County for court. Must reside at 3681 Aldea Drive in Decatur. I think I already said no drugs, no alcohol, no weapons, no replicas of weapons. You're going to have an ankle monitor paid for by the county, if that ankle monitor is available, with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Let's see. These are a victim witness person on here. Ms. Rivera, have you guys had any contact with the alleged victim?
We left a detailed message for the victim.
Oh, okay. No further contact with Jaborius Bird, Jaboris Bird, BYRD. Oh my God. 15,000 and 4,000. Best of luck to you, sir. And I'll be glad to reach out and put that in my email to the state. You can lead a meeting. Dion.
Thank you, Judge. May I please be excused?
Yes, ma'am.
Sir, thank you.
Deshaun, sure. Alexander. Mr. Alexander. Nobody in here named Mr. Alexander. Okay. What about Jamonte Akins? There we go. Number 1, 23 CP 223680, 91 days without indictment. Looks like there is no bond on this for willful obstruction of a law enforcement officer because it was under pretrial. Then pretrial came off of it. Felony. Then we got another 91 days without indictment. 23 CP 223913, willful obstruction of a law enforcement officer felony, willful obstruction of a law enforcement officer felony, and criminal trespass. Rah.
He has 7 cycles. The last arrest was November the 25th, 2023 in Fulton County for felony obstruction of an officer. He does appear to have 2 open cases pending in Fulton County. One for Schedule 2 controlled substance and giving false information to an officer. That case number is 23 CP 218594. And the other case is giving false information to an officer, an obstruction of an officer, and simple battery. That case number is 23 CR 007011 and the letter D. He does appear to be on probation in Fulton County. That case number is 14 SC 130206 for armed robbery. That disposition date was July the 27th, 2015. 7 years of confinement and 3 years of probation. Nothing in addition, Your Honor.
All right, go ahead, Ms. Safarasi, you hear from Ms. Strong?
Yes, Your Honor, I'm actually his attorney on both cases now. Ms. Strong
Okay, go ahead.
represented him on the other case. Yeah, Mr. Akins has been incarcerated since early December of last year. This is the first time he is brought before for a bond hearing. So he's legally entitled today because it is past 90 days. The case that ends in, I believe it is the 8-0, the one that the Strong was on, he had a UJR in that case, was released, and then they served this case on him. And so pre-trial came off of his bond because of this case. So, Your Honor, I'm asking for you to reinstate that case and then to set a bond on this case. So I'm asking to reinstate the case that ends in 8-0 and then have a bond not exceed $10,000 in the case that ends in 1-3. Mr. Akins is 23 years old. We have a good address in Atlanta, Georgia, who he resides with his family members, whole life here in Georgia, born here, raised here, whole family lives here. At the time of his arrest, he was working as a line cook, dishwasher at Mary Mac restaurant, and he had that job for a year. On top of it, he was also working at a metal plant on Fulton Industrial Boulevard, so here in Fulton County. He had that job for about 6 months. He just twisted and tie, and he was in a training mentorship program where he would eventually become certified in this metal plant twisting tie. Don't know the details fully because of my limited understanding of industrial work, but he has an apprenticeship job that he was working at, and then on top of it, he was doing a dishwasher. He does have his GED, and he has a 1-year-old daughter who also lives here in Georgia. We do have some MH issues, Your Honor. All of these cases, it's that line right above bad interactions with law enforcement. And so how they actually will eventually indict these or how these cases will eventually get settled, I don't know. But none of these cases involved a weapon or anything of that violent nature, Your Honor. So again, we're asking for reinstating the first case and then not to exceed $10,000 on the second case.
Go ahead, Mr. Malkin.
All right, thank you. So he's not entitled to a bond on position number 1 because he had a bond and violated that. And now he has 4 open cases in Fulton County and was on probation when he committed these offenses. Both cases involve fighting the police, punching the police, kicking the police. In position 1, he also strangled the clerk in the case and then kicked the police officer. In the second case, he fought and punched the police officers. And so we would ask for a $20,000 bond on each case. And, I think that's fairly reasonable. And if the PD's office is able to find some sort of program, or maybe he needs an evaluation and a diagnosis, then maybe things could be revisited in the future.
All right, position ending in 3680. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1177 Lee Street in Atlanta, Georgia. No further contact with Officer Andy Dorsil, Dorsil. If available, you have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical. $20,000 good bond. On position ending in 3913, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, period. No further contact with Officer Cordell Rogers, and anytime you have contact with police officers, it's no further violent contact. No further violent contact. Stay away from 1355 Ralph David Abernathy Boulevard. So we'll do 20,000, 20,000, and then 5,000 on the criminal trespass. 20, 20, and 5. Best of luck to you, sir. You can lead the booth. Miss Alfarasi, I'm okay. Chabezo, help me with that one, Miss Alfarasi.
It's I before.
Yeah, right. I before. Okay, Mr. I before. Mr. I before.
He's right there, 4 North. Your Honor.
Okay, thanks. All right. All right. We'll start with position 10, 23 CP 223972. First name is CHIBUZO. 90 days without indictment, got burglary in the first degree, simple battery with criminal trespass, $15,000 bond as of December the 8th. 23 CP 223973, unlawful eavesdropping and surveillance, criminal trespass, 90 days without indictment, $7,500 good bond as of 12/8/2023. Position 12, 23 CP 223974, 90 days without indictment, burglary in the first degree, 2 counts of financial transaction card fraud, $14,500 good bond as of December the 13th.
Your Honor, we can waive sounding on his charges.
Oh, what is that on his pretrial report? Okay, I got 23 CP 223975, 90 days without indictment, criminal trespass, financial transaction card fraud, burglary in first degree, financial transaction card fraud, $17,500 good bond. Position 14, 23 CP 223976. We got CWAC, criminal trespass, unlawful eavesdropping, 90 days without indictment with a $17,500 good bond. 23 CP 223977, 90 days without indictment, burglary in the first degree, financial transaction card fraud, financial transaction card theft, criminal trespass, $17,500 good bond as of December the 8th. And last case is 23 CP 224045, 90 days without indictment, burglary in the first degree, financial transaction card theft, financial transaction card fraud. There is a $40,000 good bond as of 12/12.
He has 3 cycles. The last arrest was August the 8th, 2023 in Cobb County for criminal trespassing. There was no disposition for that arrest. He does appear to have an open case pending in Cobb County. It's associated with the CWAC. He was arrested for that charge on May the 16th, 2023. Nothing in addition, Your Honor.
All right, go ahead, Ms. Safarasi.
Thank you, Your Honor. Mr. Aberfer is 20 years old. We have a good address for him here in Atlanta, Georgia. Born and raised here in Atlanta. His whole family lives here. We do have good contact information for them. At the time of his arrest, he wasn't he was enrolled at Georgia Tech. He was in his last year. Majority of these offenses happened on Georgia Tech's campus, Your Honor. At the time, as being a full-time student, he was also an assistant at the Office of International Education at Georgia Tech. He was doing that for a year. He was studying architecture at Georgia Tech, and he actually had a scholarship. We do have some MH issues here, Your Honor. But I will say this. We went to prelim on some of these cases. The officers who took out warrants didn't seem to know the facts of the case. One of the cases we went through, and it was very clear, it was actually the CWAC charge that's on the calendar today. It was very clear that that case was going to get dismissed because they were not meeting the elements of it. And there was a big issue with ID, even based on what the officer said. The case got reset because there were so many cases. And so the case actually got reset. So he is prelim on all these cases in April. So I just, again, because I had handled one of the prelims that we had almost completed the prelim, so we're not technically finished with it. Evidence is not technically closed. But based on my questions with the officer, it was very clear that they could not pinpoint him. A lot of it is he was in the vicinity, and he's a Georgia Tech student, and so they're saying he was in the vicinity. We didn't get into a lot of these burglaries, but again, they're all just different dorm rooms essentially, and I think there might be two different halls, like dorm halls. But again, it's all Georgia Tech campus, Your Honor. And the idea of it seems like they had all these problems and they just want to throw it all on him. That's how it feels when we went through the prelim. We haven't finished going to the prelim, but based on my representation to you as an officer of the court, it was very clear, we were before Judge Wolf in December, it was very clear that case was going to get dismissed because they could not connect him with what the allegations are. If the state wants to come through and do that, that's fair. They can do that. But based on what their own witness was saying on the stand, they could not pinpoint him as the person. So I think we're going to have ID issues here. And I think that's going to be across the board with some of these other cases. We didn't get into them, but for that one case we did get into. I can tell you that, Your Honor. So I'm asking for a reduction. I'm asking for you to just cut all the bonds in half for all his cases. That's still a lot of cases. It's still a very high bond, but as his bond is now, I think he's over 200,000. I'm not great at math, but I think he's over about $200,000. It's ridiculous for what the charges are. Even the CWAC charge is very low level compared to the scale of CWAC charges, Your Honor. And it doesn't, again, fit that charge. So because of that, I'm asking for reduction on all of his cases in half.
Ms. Salfarossi, he's currently a student at Georgia Tech.
He was at the time of this arrest. He was living on Georgia Tech. He was enrolled at Georgia Tech. I don't know, because he's been in for so long now, for this 90+ days, I don't know how his enrollment is affecting with the new semester and everything, Your Honor.
Right, so he's probably unenrolled. Okay, go
Probably
ahead.
at this point, he's unenrolled. So we could stay away from Georgia Tech at this point. I don't
Okay.
have a problem with that. I just want to get his bond down so we can get him out of the jail.
All right, go ahead, Mr. Malkin.
Sure, and we would ask for no contact stay away as part of any bond order. I'm looking at one of the warrants and it says the individual that was complained about was seen leaving the residence hall and entering a car on camera, and they got the tag number and they ran the tag. It came back to Mr. Ibafor's father, and so they were able to connect him pretty well and pretty easily, also with the wireless network on campus. So for position 10, we would ask for a $14,000 bond. For position 11, we would ask for a $7,000 bond. For position 12, we would ask for a $14,000 bond. Position 13, a $16,000 bond. Position 14, a $14,000 bond. Position 15, a $16,000 bond. And position 21, a $28,000 bond.
All right.
Thank
You
you.
know, if I may just add, because I actually handled the prelim, he's a Georgia Tech student, and Georgia Tech does not have, there's no reason for him not to be on campus for him as Georgia Tech too. So seeing him leave the scene as being a student on that campus is not enough to say he's guilty of all these offenses they're saying. Just want to point that out.
Okay.
Sorted out.
Right, let's see. All right, so if he was living on campus now, where is he gonna live?
He'll live with his parents.
Is that in Fulton County?
Yes, Your Honor.
All right.
Oh, he's not in
Position-
Fulton County? He shook his head. It's not in Fulton County, Your Honor, so we can have a stay out of Fulton County then.
Okay, all right, position 10, ending in 3972. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay off Georgia Tech campus and away from all college campuses. Stay out of Fulton County. The only reason you come to Fulton County is court or to see your lawyer. No other reason. Get gas wherever you live and supply your address upon release. Do not come to Fulton County. Stay away from 630 William Street, Northwest in Atlanta, Georgia. If an ankle monitor is available, you'll get one paid by the county with a 24-hour curfew. Court, lawyer, medical, MH treatment. No further contact with John, Zeveney. Do 8,000, 2,000, and 2,000. Position ending in 3973. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from Georgia Tech campus and all college campuses. Stay out of Fulton County unless you're here for court or to see your lawyer. That's the reason, only reason you come to Fulton County. No drugs, no alcohol, no weapons, no replicas of weapons, no further contact with Anekere, last name Nischal. Let's see. So we'll do 4,000, and 2,000. Case ending in 3974, ankle monitor paid for by the county with a 24-hour curfew, court lawyer and medical. No further contact with LAEKERENISHCHAL and that ankle monitor with a 24-hour curfew, court lawyer, medical. You have to supply where you're living also. No drugs, no alcohol, no weapons, no replicas of weapons. Stay out of Fulton County, court or see your lawyer. No further contact also with BOYANG, last name WANG. So we'll do 8,000, 1,000, and 1,000. Position ending in 3975. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 708 Spring Street Northwest, Georgia Tech campus, and any college campuses. Stay out of Fulton County unless you're here for court or to see your lawyer. Don't get gas. Don't stop at Chick-fil-A. Don't do anything in Fulton County. Don't get a flat tire. No further contact with Omar, MEHBOOB, and AMOGHKASHYAP. Stay away from 630 William Street Northwest in Atlanta, Georgia. That ankle monitor, like I said, paid for by the county. 24-hour curfew, court, lawyer, medical. Let's see, I got 1,000, 1,000, 8,000, and 1,000. Position 14, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay off Georgia Tech campus. Stay out of Fulton County unless you're here for court or to see your lawyer. You can have ankle monitor if there's ankle monitor available, paid for by the county with a 24-hour curfew, court, lawyer, medical. Like I said, stay out of Fulton County. The only reason you come here is court or to see your lawyer. That's the absolute only reason. No further contact with BOYANG, last name WANG, and Omar Zahid, ZAHID. Stay away from 118 Bobby Dodd Way Northwest in Atlanta, Georgia. So 10,000, 1,000, and 3,000. Positioning in ending in 977. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. You have ankle monitor if available, and it's paid for by the county with a 24-hour curfew. Court, lawyer, medical, court, lawyer, medical only. Stay out of Fulton County unless you're here for court or to see your lawyer. Sorry, you can't even get gas in Fulton County. All right. Let's see, South Georgia Tech campuses and all college campuses. So we've got 8,000, 1,000, 1,000, and 1,000. Position ending in 4045. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay off Georgia Tech campus. Stay off all college campuses. Stay out of Fulton County unless you're here for court or to see your lawyer. You're going to have that ankle monitor if there's an ankle monitor available, paid for by the county with a 24-hour curfew. Court, lawyer, medical only. Stay away from the Glen Residence Hall at 118 Bobby Dodd Way Northwest. No further contacts with Rohan, ROHAN, last name PAI. So we got 20,000, 1,000, and 1,000. Best of luck to you, sir. You can lead the booth. All right, Dominique Russian.
Yeah, I complete my business for tonight. May I be excused?
Yes, ma'am. Have a good evening.
You too. Thank you.
All right, this is 23 CP 223935, 91 days without indictment, crossing guard lines with prohibited items or substances and disorderly conduct. Right now, there's a $1,500 split bond as of December the 7th.
I apologize, Your Honor. What position is that?
Number 16, Dominique Antoine Russian.
Thank you. He has 43 cycles. The last arrest was November the 12th, 2023 in Fulton County for reckless conduct and simple assault. That case appeared to be still pending. That case number is 23 CR 00705 4 and a letter F. He does appear to have 2 open cases pending in Clayton County. One is for battery and one is for simple battery. And he has an outstanding hold out of Tennessee for a failure to appear. The underlying charge was not listed. The date on the warrant is February the 23rd, 2023. He does have prior felony convictions. One in 2018 for entering an automobile, one in 2014 for aggravated assault. one in 2011 for felony obstruction of an officer, one in 2010 for robbery and possession of a firearm by a convicted felon, one in 2009 for possession of marijuana with the intent to distribute, and there was another one in 2009 for 2 counts of aggravated assault. Nothing in addition, Your Honor.
Go ahead, Mr. Pizzola.
Thank you, Your Honor, and good evening. Your Honor, Mr. Russian is 32 years old. He has a good address at 30055 Fireside Way, Fairburn, Georgia. He lives there with his mother. He is a lifetime resident of Georgia. He has 2 kids as well. At the time of his incarceration, he was working for People Ready, the temp agency, doing trash pickup. He'd been doing that for about 4 weeks before his incarceration. Your Honor, as you heard, he has a number of cycles. The thing that is most damaging to his case right now, Your Honor, is that he has this hold. So we've not been able to look too deeply into social programs, which Mr. Russian has explained to us would be very beneficial. In fact, this incident stemmed from an incident at the hospital when he was seeking medical care for mental health reasons. But again, with this hold, there's nothing we can set up for him because he will have to go to Tennessee first. Similarly, Your Honor, he has does not have enough funds from his couple weeks with People Ready to afford a bond, and he's unable to be helped by the bail project again due to that hold. At this stage, Your Honor, his bond is currently at $1,500. We are asking for a UJR to the hold. Again, we understand that there are a number of cycles here, but the accusation here, Your Honor, was there was this incident at the hospital while he was in the process of seeking mental health treatment. So we are asking for this UJR. So at least once he's out from that hold in Tennessee, hopefully they can find him some help. If he ends up coming back here, I understand that he still has that misdemeanor charge too. I don't know if that has been handled yet, or if he would need to go to court again. But either way, Your Honor, we're hoping that he can get the help he needs from one of those positions, just because he cannot receive it here with those holds over his head.
All right, go ahead, Mr. Malkin.
All right. We would ask for $1,000 bond. Mr. Cazzoli, is there a different amount that you would like? Willing
What
to
about under the
consider?
10% program, Mr. Cazzoli?
No, so no, Your Honor, and no, sir. The money aspect of it would be totally prohibitive of him going to that hold in Tennessee, which would then in turn be totally prohibitive of him getting any sort of mental health treatment.
So if I do the 10% through the jail or release to that bond, to the hold.
Yes, Your Honor. If it was a conditional bond, I think that would work. If you wanted to make it conditional to make sure that he does in fact get picked up, I think that would be, I think that would work out best. And then if they end up coming off the hold, we can always reapply to the bail project. The issue is that the bail project cannot help him right now with that hold.
Right. Mr. Malkin, how's that sound?
Sounds good.
Okay, so we'll do a $1,000 10% through the sheriff to the hold, and then a UJR through the jail as it stands. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 550 Peachtree Street Northeast. Let's see. Boop, boop, boop. Best of luck to you, sir. And that'll be a release to the hold. If not, it'll be a $1,000 good bond through the sheriff, through the jail program. Best of luck to you, sir.
Judge, on the disorderly conduct, is that a UJR?
Yeah, it was already a UJR.
Okay.
Mr. Russian, you're going to be picked up on the hold, sir. Or if the hold does not pick you up, if they decide to come off the hold, it will be a $1,000 bond, and we can apply to the bail project to get you out that way. Okay. But right now it is a UJR to the hold. Okay. So to Hamilton. Okay. All right. We can't hear you, sir, but that's what your bond is. Okay. Okay.
All right. Let's see. What about Anthony Norman? All right. Number 19, and I think it's number 20. 23 CP 223962, 90 days without indictment, receipt, possession, transport of a firearm by a convicted felony or felony first offender. As of December the 8th, there's a $10,000 goods bond. Then we got 23 CP 223934, aggravated assault, possession of a firearm by a convicted felon, 90 days without indictment, and there's a $30,000 good bond as of December the 7th with ag assault and receipt, possession of a firearm by a felony first offender.
He has 19 cycles. The last arrest was February the 9th, 2023 in Fulton County for giving false information to an officer. There was no disposition for that arrest. He does appear to be on probation in Fulton County. That case number is 20 SC 176812 for arson in the first degree. That disposition date was June the 16th, 2021, and the term is for 8 years. He does have prior felony convictions, one in 2015 for possession of a firearm by a convicted felon, one in 2013 for possession of a firearm by a convicted felon, one in 2012 for possession of a firearm during commission of a felony, one in 2011 for possession of marijuana with the intent to distribute. Nothing in addition, Your Honor.
All right, go ahead, Mr. Cazzoli.
Thank you, Your Honor. Mr. Norman is 33 years old. His only good address at this time is the incident location. On his previous bond, he was given a stay away, but allowed to return one time to collect his belongings. We will not be able to locate a good address, or at least to my knowledge, until we get a little closer to finding some sort of situation that he can return to once his bond is lower. But he is a lifelong Atlanta resident. He is the alleged victim in the case, Your Honor, is his mother. I don't know if the state has made any contact with the victim to figure out what their thoughts are on bond. I know the state had not made contact at the time of his last bond hearing, when his bond was denied, I believe back in February. Your Honor, again, his bond is currently set at $10,000 on that first case and $35,000 on the second. We are asking for the receipt, possession, transport by firearm to be reduced from $10,000 to $5,000. On the in the second case, we're asking for the aggravated assault to be reduced from $20,000 to $10,000, and the possession of a firearm to be reduced from $15,000 to $5,000. Again, these were two separate occasions. That's the reason for the two firearm possession charges. So that would be a total of 15 and 5 for a total of 20 between the two cases.
All right, Mr. Malkin.
Thank you. We did speak with the victim in this case and his mom. She is against bond. She is in fear for her life. And she said that Mr. Norman needs MH therapy. And he's on probation, as we heard, for arson in the first, which is potentially a very dangerous offense. And the state believes that he does pose a significant danger to the community, risk of committing new crimes, risk of intimidation of witnesses, and asks that the bond remain the same. Thank you.
And Your Honor, I'm sorry, but before your decision, I just wanted to let you know that in Odyssey, it does mention time served next to those arson charges. I don't know if that was what it was previously set at, and then there was a probation issue, or if it's referring to the probation issue. I did just want to bring that to the attention of the court.
Okay. All right. Position 10, ending in 962. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Need to supply an address upon release of exactly where you'll be living. Get you a $8,000 good bond. You're going to have an ankle monitor paid for by the county if available. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working, and also mental health treatment. Position 20, ending in 934. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Shirley Norman. Stay away from 392 Boulevard Northeast in Atlanta, Georgia. Can return one time with law enforcement and only one time with law enforcement to pick up your personal belongings. Ankle monitor with a 24-hour curfew. Court, lawyer, medical, employment. You have to supply the name of your employer, proof of employment schedule, and the exact location you'll be working, and also mental health. So we got 18,000 and 10,000. Best of luck to you, sir. You can leave the booth. All right, now we've got Dondra out. Thank you, Mr. Cazzoli.
Yep. Thank you, Your Honor. Mr. Norman, so that's going to be 28,000 on the aggravated assault case and 8,000 on the other case, sir. So not as low as we wanted, but I'm going to submit a new bond request this afternoon. Okay.
Let's see, so we got one extra person here. Is either one of you Curtis Epp? Mr. Epp, your bond was addressed on the 21st You got a $70,000 good bond, okay?
Judge
So you-
Benton, count 5 needs to be addressed.
Count 5 does?
Yes, there were only 4 charges.
Is
and the
that firearm
court-
by convicted felon?
Right, that's the count that you need to address. There were 4
Okay,
counts
alright.
on here, and that's the only one that needs.
All right, Curtis Earl F. That's 23 CP 222733. So you've got aggravated assault, firearm by a convicted felon, firearm during the commission of a felony, aggravated battery. And what's the other charge?
The use of a firearm by convicted felon during the commission of a crime, that's the one that wasn't addressed.
Okay, possession of a firearm during the commission of a crime. Rah.
He has 40 cycles. The last arrest was May the 28th, 2022 in Fulton County for a failure to appear. The underlying charge was a misdemeanor, a DUI. There was no disposition for that arrest. He does appear to be on probation in Fulton County. That case number is 19 SC 172049 for possession of methamphetamine. That disposition date was January the 16th, 2024, and the term is for 2 years. He does have prior felony convictions, one in 2012 for felony obstruction of an officer, one in 2007 out of DeKalb County for robbery, one in 2005 for possession of marijuana with the intent to distribute, one in 2003 for theft by taking, and one in 2000 for burglary. And there was one in 1999 out of DeKalb County for entering an automobile with the intent to commit a theft. Nothing in addition, Your Honor.
All right, go ahead, counsel.
Thank you, Your Honor. Mr. Epps is 41 years or 42 years old, sorry. A lifelong resident of Atlanta. He does have a good address off of Parkland Drive that is in Fulton County, so that's where he would be residing if he's released. Your Honor, he has his GED. He's also, prior to his arrest, was employed as a truck driver for the past 2 years, driving box trucks. Your Honor, he's also a father to 3 children. They all live locally in the area that he has a shared custody of and helps take care of financially, Your Honor, as well. So he does have strong connections to the community. Your Honor, he already has the bond set with his other charges currently totaling $70,000. So we would just ask that bond be set on this 5th charge here, not to exceed $5,000 total.
All right, go ahead, Mr. Malcolm.
What I'm thinking is we should probably just add a bond that's the same amount for the other similar charges. Can you see what they are?
That's a $10,000 good bond.
So why don't we just add another one of those?
I'll put 10,000 on the other weapons. So there'll be 10,000 on the additional weapons charge. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Ankle monitor paid for by the county if the ankle monitor is available with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. So no further contact with Quenisha Brown. That'll be another $10,000 good bond. Best of luck to you, sir. You can leave the booth. Dondra Alexander.
And Your Honor, that concludes my business. May I be excused.
Yes, sir. Have a good evening.
Thank you as well, Your Honor.
All right, I got 23 CP 223883, 91 days without indictment. No bond as of December the 6th for criminal damage to property in 1st degree and aggravated assault. Right.
He has 26 cycles. The last arrest was October the 24th, 2023 in Fulton County for driving without a valid license and a hit and run. He does appear to have an open case pending in Fulton County. That case number is 23 CR 006686 in the letter F for no insurance and driving without a valid license and a hit and run. He does have prior felony convictions. They're out of Texas. One in 2021 for theft by receiving stolen property. And one council may want to waive sounding on.
CWAC?
I will. waive sound.
It doesn't appear to be a CWAC, it's just injury to someone that's underage.
Okay, gotcha.
17 for theft of property, and one in 2015 for theft of property, and one in 2014 of theft of property, and one in 2013 for theft of property. Nothing in addition, Your Honor.
All right, go ahead, Mr. Rogowski.
Yes, Your Honor. Come before you is Mr. Dodger Alexander. He is 30 years of age. He's been residing in Atlanta for over a year now and has a good address at 2830 Lejean Drive in Atlanta, Georgia. That is spelled Lajean. And the zip code on that is 30349. Your Honor, Mr. Alexander made it all the way through high school, as well as completed some college at University of Texas Business. Your Honor, he has his own tattoo business where he does tattoos and piercings and has been doing that for 11 years. From what I understand as well, he's incredibly talented with that, even doing some of his own tattoos. Your Honor, he has 2 children, a son at the age of 7 and a daughter 1 year of age. Since this has gone further than 90 days without indictment, Your Honor, Mr. Alexander is entitled to a bond today. Given the client's indigent status, we would be asking that a reasonable bond be set not to exceed $9,000.
All right. Have we heard from the victim?
No, I don't have any victim information on this one, Your Honor.
All right, go ahead, Mr. Malkin.
We would ask for a $25,000 bond on each count.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 2138 Benidom, Benidom Court in Atlanta, Georgia. You're gonna have an ankle monitor available, paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. No further contact with Angela Sanders, Marquavian Shearer, Sherrer. And next one is no further contact with Zareiah Kennon, Kennon. 20,000 and 25,000. Best of luck to you, sir. You can leave the booth. Looks like that's it for the night.
Excellent.
Outstanding job as usual, Miss Bosky. Keeping up with me. Keeping up with me. That's a job in itself.
Good morning, everyone. Words of grapevine furniture. Beautiful day, great to be alive. It's a wonderful day here in Michigan. We have a landlord-tenant docket this morning with a couple of civil matters in between. And then we don't have anything scheduled this afternoon. We were talking late in the day yesterday. Deputy Tyler was about to have a grandson. About 4 o'clock this morning, his grandson Tate was born. 9 pounds, 2 ounces. So congratulations to Deputy Tyler and his family. He's very excited. It's his first grandchild. So good for them. We have some new cases, some continued cases, and a little bit of other stuff. Got one person in the waiting room. And next week, Judge Pattison will be on vacation. So I'll be covering his docket and my docket. So we're going to be busy on Monday, Tuesday, Wednesday. And that's good. And a lot of people are off next week, and I hope maybe you are. Where we are. our visitor from Raleigh, North Carolina, Todd. I hope he made it back safely. He was here all week. And we also had our visitor friend Fredonia from Grand Rapids. And he used part of his day off. And so we had some people here in the courtroom this week. Okay. And good morning, Scotland and South Central Pennsylvania and New Brunswick. I never know what time it is in New Brunswick. Is that the province? It's a half an hour off. Anyway, we've got at least one attorney in the waiting room. Thank you all for saying good morning. It is a very good day here. I started a little early because we had some time. So thank you all for saying good morning. Appreciate you all being here. Let's get to work. And I will remember to turn the record on. It's register of actions. Good morning.
Good morning.
I haven't seen you in a while. I didn't know if you got out of the business or everybody was just paying the rent. I don't know if you've been here yet this year.
I have not been here this year, and we think everybody's paying their rent now, Your Honor.
Well, you're certainly busy. I hear you on the radio and you're dealing with the hospital, and so I didn't figure you were sitting around doing nothing, but it's nice to see you, even if it's just online.
Good to see you too. When I used to do automotive finance, we always said people paid for their car first because it's easy to repo their car, but it's hard to evict them or foreclose, and they need their car to go to work. Well, now they don't need their car to go to work, and getting evicted or foreclosed on leaves you with nowhere to live. So I think they're paying their rent first.
Well, let's hope so. People are struggling.
Yes.
Our rents are substantially lower than regionally. They had a thing in the MLive, Michigan Live, about the rent rates in Kalamazoo, and ours are lower than theirs, certainly lower than the big cities, but people are still struggling. This one is a service by attachment. Is the defendant still there?
To the best of our knowledge, the defendant is still there.
All right, let's see if anybody is here. The bailiffs aren't picking up. I'm not sure what's going on out there. Well, that's disconcerting. Well, I usually check to make sure they're not here. It is 9 a.m. Going to call our first case, which is Block 14, Inc., versus Gary Miller. This is a property at 210 North Street in Sturgis, apartment number 5. Attorney Jeremy.
Sorry, sir, I was dealing with people coming in.
Do we have anyone here from landlord tenant? I'm looking for Gary Miller.
I will double check.
All
I
right.
just had people walk in.
All right, thank you. Bailiffs, we're tied up. Since you've been coming, Meg Bauer has been joining us from Legal Aid, and very often she's here to provide advice or put in a breakout room. Anyway, she's here with us. Good morning, Ms. Bauer.
Thank you, Judge. Good morning.
This is Attorney Jeremy Gump. He comes in from time to time on behalf of Block 14, one of the landlords in Sturgis. He's one of the owners of the company, but
Nice to meet you, Jeremy.
Nice to meet you as well.
No, sir.
All right. The defendant is not here and he's not here. This is a demand for non-payment of rent. The defendant was served by attachment. According to Attorney Gump, he believes the defendant is still there. We start on time, which is good. The attorneys know if they log in, their case will be heard basically when it's scheduled, but sometimes the defendants don't adhere to that. And often they show up late, or in this case, perhaps not at all. What's the current arrearage in this case?
With rent being due July 1st, that would bring the total to $3,250.
What do we have for court costs? $55 filing fee. Let's see the service fee. $55.54 for service. Attorney fee is $75. So that's $110.54 plus 75 is $185.54 plus $32.50 equals $3,435.54. Now, the law requires we adjourn this for 7 days, but next Friday is I won't be here. In fact, I'm not sure who's going to be here, but so that will take us to Monday, July 8th. Because it was served by attachment, I can't do a default. Is 120 acceptable, July 8th at 120?
I believe so. One moment, please. Yes, that is good. Thank you.
All right. He has further hearing, and he probably won't show up for that either. That would give him until July 18th. We'll be in the month of July. So we will address this further 10 days from now on July 8th at 1:20 p.m. Mr. Gump, I'll see you around. You're good to go. Thank you.
All right. Thank you, Your Honor. Have a good day.
All right, we're working on it. All right, here's Ms. Larrick. Good morning. Good morning, Miss Larry. Can you hear me?
Yes, I can. Morning.
Good morning. Meg Bauer is here with us also. It's a couple minutes till this case officially starts, but while we're waiting, you're there from Richmond International Headquarters.
Yep.
What's the current arrearage?
Rent owed is $2,617.04.
Through when?
Through June.
All right. And what are court costs?
$184.08.
What does that bring us to?
$2,801.12.
They were both personally served. Are they still there?
As far as I know, yeah. I spoke to them about probably 2 weeks ago, and he said that he had just found a job and was going to get help getting caught up on rent, but I haven't heard anything from them since. So
Meg shared an email with me, and then I talked to them myself. Neighborhood Inc. is out of money till the next fiscal year, and I wasn't clear when that is.
Yeah.
They have some limited emergency money, but they're not going to be a factor for a while.
Yeah.
I don't know about Community Action or DHS. We'll see whether they show up here. We've got 2 minutes.
Okay.
Did you inherit these tenants or did you start this?
No, I inherited them.
They've been there for some time.
Yes.
Tell Larry to quit pounding on stuff back there.
I know, he's upstairs doing flooring.
Okay.
He's just practicing for when the courthouse is being repaired.
Judge Pattison brought in, he's the chief judge, and he's going to be here after I'm gone. And he's intimately involved in the new design of what's going on here. This is the third or fourth time we've done this. Fly specking drawings, and they've had a couple previous plans that they didn't follow through on. But this commission is going to follow through on it. So I'm not sure what the next year holds, 2025, but I think it's going to be a big mess.
Yeah.
Anyway, we're trying to, so he blew up the drawings and we've been fly specking them. It's going to be very unpleasant to live in it. And I've done it before when they did the old building, but they didn't disrupt this one. But that old building was stripped down to the bare bricks, and new plumbing, new electrical, new mechanical. They savored the old traditional feel of the building. They did a good job on it.
What's
I'm
in
not
the
sure
Three
what-
Rivers? What's in the Three Rivers? I saw they turned the old library.
Judge Tomlinson's, the probate and the family court are there, and the juvenile court, also the friend of the court.
Oh, okay.
And then in the back part of it is the juvenile day treatment program. So they've used the whole building.
Yeah.
Well, they're not here. I expected maybe they would be here. They were both personally served. So they would be subject to default, meaning we could simply enter the judgment at this time. I'm gonna let the clock tick a little bit. You've been around long enough that you obviously know you don't have to evict them on the 10th day. Here they are now. They're only 1 minute late. They're both on separate phones. Good morning, Mr. Allen, can you hear me?
Yes, I can.
Ms. King, can you hear me?
Yeah, I can.
All right, if you guys are too close together, I'm gonna get feedback, but I think this will work all right. Thank you for being here. This is file 24734LT. It's entitled Lydia Larrick versus Theron Allen and Chloe King. Am I saying that right?
Yeah.
Ms. King, how do you say your name?
Chloe.
Chloe, all right. Just a different way to spell it. All right, your landlord, Ms. Larrick, says that you're behind on your rent. Through June, she claims the rent is $2,617.08 behind. Plus cost brings the total through June of 2801.12. We'll talk about July here in a minute. Ms. Larrick is here on the live feed, also present. You can see her on the screen is attorney Meg Bauer from Legal Aid in Kalamazoo. As a tenant in a landlord-tenant proceeding demanding non-payment of rent, you have the following legal rights. You have the right to have an attorney. If you cannot afford an attorney, the court can give you information about legal aid. We already sent you that information, and legal aid is here. We don't have court-appointed attorneys in civil cases like landlord-tenant, but if you're eligible, you may be eligible to get some representation or at least some advice. You have a right to have the case heard here in St. Joseph County where the property is. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at the first appearance, make the demand in writing within 5 days of today using the jury demand form, MC 22. You must pay the $50 jury demand fee when you make the demand, or ask for a waiver if you're unable to afford the fee. In this case, your landlord has asked you to be evicted from a residential property because you haven't paid rent. You may be able to get assistance from the Michigan Department of Health and Human Services, a coordinated entry agency, a housing assessment and resource agency, or if you're a veteran, possible veterans programming. We sent you that information with the original packet. You may be able to reach an agreement with the landlord by going through a local mediation service. If both parties are interested, the court can help set that up. If you are able to reach an agreement with the landlord, that means the case would get dismissed. We would file what's called a conditional order of dismissal, and the court would either provide you with that form or tell you where to find it. Ms. Larrick says that the rent through June is $2,801.12. Ms. Larrick, the rent is $670 per month.
Yes, it is.
So if we add $670 to that, $2,801, well, I'll start at the beginning. 2617.04 plus 670 gives $3,287.04. Plus court costs of $184.08. That consists of the filing fee, the service. Oh, there's no attorney. Okay, filing fee and the service fee. And you both got served, which is why it costs more. 184.08. Total would be $3,471.12 to pay your rent through July. Now, Ms. Larrick said that you guys were seeking some financial assistance from somebody. Have you tried to get some help?
Yeah, we have tried to get help and just haven't been able to.
Who'd you apply to?
Where did we apply to? Yeah.
Well, we have Neighborhood Inc. They're out of money. DHS or Community Action Agency, but so you were denied any emergency assistance?
Yeah.
She also said, Mr. King, that, or Mr. Allen, that you'd gone back to work.
Yeah, I just started work about 3 weeks ago.
Where's that?
It's MCM in Vicksburg.
You have a new baby?
Yeah, he's 8 months old.
Ms. King, are you working?
Not at the moment, no.
All right. Well, the law requires that we adjourn this matter at least 7 days. And that would be next Friday, and we won't be in session that day. So it takes us to Monday, July the 8th. And that would be at 1:30. Does that work for you, Ms. Larrick?
Yes, it does.
Now that we've added July's rent in here, the total amount that you would be required to pay would be $3,471.12. If you're unable to pay that, you would be subject to being evicted, meaning the sheriff could come put your stuff out. That would happen 10 days after July 8th. So you would have until July 18th to pay the rent or be subject to being evicted. Ms. Larrick doesn't have to evict you on July 8th. She has 56 days from today to ask for the, 56 days from the day we enter the order, to ask for the writ of eviction, which would take it sometime into August. So if you can agree on some sort of plan to get caught up on this, then I'm certainly in favor of that. However, if you can't, you're subject to being evicted and you need to find another place to move to. Do you have a plan here?
No, I do not.
But you do wish to stay there?
Yeah, I really do want to pay it up. I've just been working for 3 weeks.
I can call you. I can call you there and we can see if we can come up with a payment plan.
Yeah, that'd be awesome.
Why don't you guys discuss that? We will be back here 10 days from now, Monday, July 8th at 1:30. Do you have any questions?
I do not.
All right, you and Miss Allen can discuss this. Hopefully you can work something out. If you can, we could do a conditional order of dismissal, or sometimes a little earlier in the year, people are getting income tax refunds and they get the refund and they get caught up on their rent. I think we're past tax refund time. But sometimes you take a new job, it takes you a couple weeks to just get your first check. And this isn't your only bill. You have gas, car insurance, food, that sort of thing. But you're on the precipice of being forced to move out. So hopefully you can come up with a plan to get this rent caught up. Anyway, I'll see you on July 8th. You're both good to go. I've got to remove from the queue.
Thank you.
Thank you.
All right, Miss Larrick, I'll see you next time. Thanks.
Okay, thanks. Bye.
Bye. Good morning, Mr. Shefferly.
Good morning, Your Honor.
Welcome back to Centerville.
Thank you.
It is 9:20. It's time to call our next matter. It's called Veterans Affairs, Secretary of Veterans Affairs versus all occupants at 16840 Mittendale Road. The attorney of record is Mirella Albu. You can imagine how disappointed I was when I saw you were here instead. But you're members of the same firm. She
Yes, sir.
covers for you. You cover for her. There was a sheriff's sale, a mortgage sale last October 5th, and the redemption period on this property has passed. It sounds like it's vacant. It was served by attachment. And it looked like the occupant or owner was a David Kate. Do you have any more information about this, Mr. Shefferly?
No, Your Honor, we haven't had any contact with the mortgage or anybody that might be living in that property. I think there's personal property that's been left there. And so we just wanted to make sure we got an order before we went in and got the stuff out of there.
Because it was served by attachment, I can't do a default at this time. We aren't here next Friday. Probably you aren't either. I think everybody everywhere took Friday, the 5th of July off. But that would extend us to 2 p.m. on July 8th. Does that work for you?
That's fine, Your Honor. The only thing I think there was a request for mailing, Judge. If the court wants to adjourn this, that's fine with me, but I just wanted to, I think our firm always does a request for mailing in these circumstances.
There was. It was done way back on April 9th, but I don't know when you're mailing it to all occupants. It doesn't go anywhere.
Understood.
It's already been attached, so let's just continue to July 8th. We'll get a default, and then you can get the property.
Very good. Thank you, Judge. I appreciate it.
All right. Enjoy the rest of your Friday. I'll see you next time. Thank you.
Thank you so much. You too.
All right, our next matter is at 9:30, which is 7 minutes from now. It's been pretty uneventful so far. I imagine you see trot and trot all over the place. Everywhere you appear, they do these all over the state. Good morning.
Good morning. Are you ready for
Yes, they can come in.
Yeah, we see them. Don't go against them very often, but do see them, of course. Yeah.
Well, like the last case, many of their cases are defaults. There was a mortgage sale. The people have vacated. Although we had that case last week with Mr. Ash, where it was a mortgage sale and the redemption period had passed. Come on right up. And he was totally unprepared for this. And I'm not sure what he was told by the bank anyway.
And we do actually have a fairly robust foreclosure prevention and team, I guess. Obviously, by the time they're at this point and the redemption window's closed, it's very,
Well,
very,
he
very
had contacted legal aid and they told him they wouldn't represent him.
Yeah, I think I was reading the notes in that case at the time. Obviously, I can't talk about it, but
And I don't know. What the truth is. You get part of the story, his version, and he wasn't very clear on everything. So I don't know what really happened, but I know that the sheriff's sale had taken place and it hadn't been redeemed. Good afternoon or good morning, excuse me. We've got some live customers here. And we have a 9:30 hearing. So we'll let the clock tick for a little bit. This is Frank and Karen Roberts versus Shelby and Chester Parr. Frank and Karen Roberts are here with me. They have had some courtroom experience. We had quite an extensive trial a couple of years ago on a case. Good morning.
Good morning.
Welcome back. Drop my pen. We do a lot of this, just sitting here letting the clock tick from one case to the next.
There ought to be three of you.
Well, either that or I ought to be able to just hit the fast forward button. But this makes things take longer sometimes, but that's how it goes.
I will admit, Judge, it is helpful that you can use double playback speed on YouTube. So when I am playing catch up on things, it does help a little bit. No real life fast forward, but
Yes.
most of
Probably
us would.
people fast forward through everything.
Some of us would probably, the rewind button would be just as desired for a lot of people.
I'd hope that here they are, somebody is iPhone. Good morning, Ms. Park. Can you hear me?
Yes, I can hear you.
Is Chester there with you?
He is not. He could not get out of work today.
All right. Mr. and Mrs. Roberts are with me here at the courthouse. You'll be able to see them in a minute. Also present is Meg Bauer from Legal Aid. She's an attorney with Legal Aid in Kalamazoo.
It's available if you're interested in speaking with Legal Aid, Ms. Parr, after the proceedings, of course.
All right, thank you.
Where's Buddy working?
AutoZone and Three Rivers.
Oh yeah, I knew that. All right, let me call the case. This is file 24761LT. Frank and Karen Roberts are present here with me at the courthouse. I want you to speak. Just say good morning.
Good morning, Judge.
Morning.
Morning, Shelby.
All right, that triggers their camera. Ms. Shelby Parr is here and Chester Parr, her husband, is not present. This is filed as a termination of tenancy case for a property on Coon Hollow Road. And I knew you were living there, Ms. Parr. There was a warrant for your arrest that had been out for like 2 years, and they never bothered to serve it. Finally, when they did serve it, the prosecutor dismissed the charge. So that case is over and done with. But in the meantime, we have this case. It's filed as a termination of tenancy action. So let me tell you what your rights are as a tenant in a landlord-tenant proceeding. This is Nathaniel Ratliff. We'll bring him in. No night sweats. I think it's actually Ratliff. Actually, it looks like him. We've met before. Nathan, would you please come in? I'd like him to come in so I don't have to go through the rights twice. So we'll see if we can get him in. Mr. Ratliff, could you come in, please?
Hello.
Good morning, sir.
Sorry, I've been trying to figure it out all morning.
All right, well, you've been here before, but good morning. This is Judge Middleton. Your case will be next. We're working on another one right now, but let me tell both of you. You are tenants in a landlord-tenant proceeding. As such, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. We don't have court-appointed counsel in landlord-tenant cases. You have a right to have the matter heard here in St. Joseph County where the property is. Mr. Ratliff, if you've got something else turned on there, which is feeding back, have you got a... All right. You have a right to have the case heard here in St. Joseph County where the property is. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at the first appearance or make the demand in writing. Mr. Ratliff, what do you have on there? You have something more than, you have a phone and a computer on?
No, I have a phone on.
Anything else?
No.
All right, well, we'll just live with it.
I could try my phone case. I don't know.
No, you're fine. But there's feedback someplace. You have the right to demand a jury trial. If you want a jury trial, you must tell the court at this initial appearance or make the demand in writing within 5 days and file the $50 jury demand fee or request to waive the fee if you cannot afford it. Your landlord has asked you to be evicted in Mr. Ratliff's case because you've got unpaid rent. You may be able to get assistance from the Department of Health and Human Services, local coordinated entry agency, a housing assessment and resource agency, or other perhaps veterans program. You do not need a judgment against you to get help from the places listed above. Copy of the summons and complaint from your case are sufficient. If you are able to reach an agreement with the landlord, we can file what's called a conditional order of dismissal. And if the parties are agreeable to some sort of a settlement agreement, we could refer the matter for mediation to the Citizen Mediation Authority. So, Mr. Ratliff, I'm going to mute your microphone while we deal with the other case because your system's feeding back.
Okay, yes, sir.
Except all right, Ms. Parr blipped out. And she's back. Ms. Parr, all right, good morning. All right, this is filed as a demand for non-payment of rent. Excuse me, as a termination of tenancy in this property on Coon Hollow Road. They wish you to move, but I'm advised that you've already moved out. Is that correct?
Yes, that's correct.
Do you have a new address?
Yes,
Just tell me what street it's on.
Country Lane in Constantine.
Do you have any objection to Roberts taking immediate possession of the property?
No,
Mr. and Mrs. Roberts, have you recovered the property?
Yes.
All right. The problem is there's substantial damage to the property. Frankly, Ms. Parr, I was shocked at the pictures that they provided. So we have the first part, which is the possession part. And then we have to deal with the damage part. They're asking for money damages. And that is going to be at a separate hearing. And right now, I don't know how much those damages are. Mrs. Roberts, how much do you claim are the damages at this property?
I don't think we.
Calculated them yet?
I thought you did somewhere there.
I also have a video of the property that I left in the condition it was in. That
All right.
property was not up to par to begin with, and I have lots of pictures and everything and proof to prove that the property was already damaged before we even got there.
All right, well, that's what trials are about. I haven't made any decision. They get a chance to provide their evidence and you get a chance to provide yours.
Okay.
But right now, I'm not even sure how much they're asking for. When you move out, you're supposed to turn in your keys and give your forwarding address in writing within 4 days. And that triggers the security deposit law. So they did pay the fee for supplemental damages, and we're gonna have to set a hearing on that. But at this point, I don't know what the damages are. Miss Roberts, how much are they?
I didn't add them up totally.
All right, well, we're going
Because
to
we
have
weren't
to set
finished.
this for a hearing. Right now, Ms. Parr, you have no objection to them taking immediate possession of the property, is that correct?
That's correct. That they should already have a possession because I texted
Yeah,
them
they
about
do.
a while ago that
All right,
we were out.
okay.
I would guess it's somewhere about 6,000 or 7,000.
Yeah, that's definitely not accurate.
Well, like I said, there's two sides to each story. So there may be issues regarding unpaid rent or damages.
That didn't include the rent.
All right. Plaintiff can have immediate possession. Shows a consent and a default as to Chester. You have 21 days to file your complaint for supplemental damages. So we're gonna have a hearing regarding the damage, and you've been through this, and you know it was very difficult. But you have to file this complaint for supplemental damages and tell me how much it is. How much is rent? How much are unpaid utilities? And then how much is damage, broken windows, carpet cleaning, trash removal, that sort of stuff. Then you put in the security deposit and then subtract that, and that's the amount that you're asking for. Then Ms. Parr is gonna have a chance to answer the complaint. So it may be a little later this summer, like August, before we actually have a hearing on this. But you can have immediate possession of the property. I will put no money damage. We will plaintiff to file damage complaint within 21 days. So there are a lot of pictures here, which you probably don't have a copy of, Ms. Parr.
No, but I have them.
No.
All right, so I have a set for you. And So they're gonna file the complaint and say, this is how much we claim that she owes. And she says it's about $6,000 or $7,000.
Plus the rent.
Okay.
Can I ask you a question?
Just a minute. And then you'll get her complaint. This is how much we're asking for. Then you have a period to respond to that. And then I'll set a hearing where everybody will come in. They'll be under oath. I'll look at pictures, I'll look at videos, I'll look at receipts for things that were purchased or services like trash removal, that sort of thing. It could take half a day. But from the pictures, it doesn't look like it was left in very good shape. But this is an old farmhouse. I'm familiar with it. I've driven past it 1,000 times. So it's going to take us a while to get through this. You're entitled to know exactly what it is they're asking for. So we got $6,000 or $7,000 worth of damage plus rent. So I'm not sure what kind of total we're talking about. Also, if Chester doesn't show up, he gets defaulted. So he can't have you represent him in this. So we could have the result where we would have a hearing and you'd present all of your defenses. And if he wasn't here, the default judgment would enter against him. So it's okay that he's not here today. This is a possession and that you've already left the property. But when we get into the damage hearing, he needs to be here also.
Okay.
But I understand he didn't want to miss work or lose wages for this, although he could have dialed in from his phone. Ms. Parr, you have anything else you want me to know at this point?
No, so basically I just have to wait for them to do.
Yes, they'll file their complaint
stuff.
and list the amount of damage, rent.
Okay.
Unpaid utilities, damage, carpet, windows, trash, that sort of thing. And then they'll say, this is how much we're asking for. Then you have 21 days to respond.
Okay.
Mr. and Mrs. Roberts, you have a question?
I did. Since we couldn't get on the property, are they responsible for the rent until that time?
Well, we'll be asking about that very question. So today we're still in June. So if you're saying you can demand June's rent and she can say, well, I told you I left on May 31st. So that's something that's in dispute, which will be discussed at the trial.
Okay,
And you have a set of pictures here with you for her?
yes.
All right, leave those with the clerk and we will see that she gets a copy of those pictures as well.
How about the papers?
Yes, everything you've got needs to be served on her, but you need to file a complaint saying this is how much the damages are.
Okay.
And you did a good job in your last case. But what I want you to do now is go out to the clerk and get a copy of this order. You can have possession of the property effective right now. So you can go in, assess it, and then file the complaint for money damages. She'll file an answer. Everybody will be here live in person and we'll have a trial regarding who owes who how much money. All right, if you go out to
I'd like to say one thing if I could.
Yes, sir.
You know, and she was there quite a while. She was a pretty tidy woman. But you know, she come on, we was told her she's gonna have to pay her rent and want her to move out. And she kind of went berserk.
Well, we don't need to get into that here. We'll sort it all out. I've known Miss Parr since she was in high school. She has a good job.
Yeah.
She's had some other struggles with her ex, but let's see what we can sort out with this.
Okay.
We'll save it all for the trial. Miss Parr, you're good to go. In fact, I think she already left. Oh, there she is. All right,
Okay.
thank you. Go out to the counter and we'll get that for you.
Yes,
All
sir.
right, thank you both.
Thank you.
All right, we're gonna move ahead here. We're up to 940, which would be Elm Tree Apartments versus Nathan Ratliff.